Yeah, Lordship.
Yes.
Yeah, Lordship, I'd like to mention item number 12. On behalf of Mr. Raksav,
Item number 12.
Lordship. Lordship, Mr. Raksav is out of station. So,
Who is Alpame?
and for the respondent, Mr. Raksav, Ramji Raksav,
Have you informed the other side?
we have taken the consent.
Where they are? Huh? Interim order was there. On the request of your Mr.
JSRO,
On the request of Mr. J. Sir, appearing on behalf of Mr. R. The learned counsel for the respondent. And with the consent of the other side, we receive the adjourn. And the
What's it?
matter be listed after
3 weeks.
3 weeks. Interim order be continued till the next set of list.
Deeply obliged.
Lordship, Lordship, I beg to mention item number 4, Lordship. Lordship, I'm on behalf of the petitioner. We have to file an additional affidavit, Lordship. So we are praying for an adjournment, Lordship. We are going to file an additional affidavit. So we are praying for an adjournment, Lordship.
Heard Mr. Jindalo, the learned counsel for the petition. And it is submitted by him. It is submitted that he is going to file an additional affidavit on behalf of the petition. If they are allowed, let the matter be listed after 1 week or 2 weeks,
3 weeks, Lordship.
after 3 weeks,
Lordship, there is an interim order, Lordship.
after 3 weeks. Interim order be continued till next date of list.
Much obliged, Lordship.
Well,
Yes.
before the FIR, kindly come to paragraph 10,
Paragraph
10, page 9 of the criminal reason.
yes.
But the accused preferred default bail under 167, clause 2 of the CRPC. Then what had happened is, Milord, kindly see in the box, Milord, in the box, FIR was lodged on 25.
Yes.
Page
25
yes, 25(9) FIR was lodged. That is at page 22, Milord, we need not to peruse this. Accused person was arrested on 25(9). The challan is there at page 23, Milord. Then remand order was passed on 26, Milord. 26/9/2023. So then serial number 4 would indicate, Milord, that 90 days mandatory period expired on 24/6/2023. Then, Milord, kindly come to next serial number 5. Default bail application was filed on 26/12/2023. Kindly come to, Milord, page 31 for a moment, Milord. Default bail application.
The application for default bail.
Default, Milord. This is default. Only for that purpose, Milord. Then I'll come to the main judgment. Then, Milord, what had happened? Charge sheet was filed on 3rd January 2024. Now, the learned court below, I appeared in this matter. The learned court below tried to commit a procedural error. But I said, M. Ravichandran judgment is very clear that if the accused has invoked the mandatory provisions of a default bail, must hear the default bail first, then the court has the inherent power of taking cognizance and next date for the consideration of the charges. Now, Milord, kindly come to now for a moment, Milord, the grounds that I have assailed is at para 12, page 9 to 12, Milord. Only E and F may kindly be seen, page 12. Page 10, my lord. For that, the findings returned by the learned court below is not correct and legal, as it is a settled position of law that once the accused file an application for bail under the proviso to section 167 clause 2, he is deemed to have availed. Well, that judgment I will place it not required also, it's there. Now, well, for a moment, kindly come to page 10 again, page 8 again. Kindly flip back to page 10. Well. Now, the default bail was filed on 26/10. That means I have able of or enforce his right to be released on default bail occurring after expiry of the stipulated time for the investigation. Thus, if the accused applies for a bail under section 167 CRPC upon expiry of stipulated period, as the case may be, the court must release him on bail forthwith without any unnecessary delay after getting necessary information from the public prosecutor. First thing, my lord, the learned court below have failed to appreciate the proposition, my lord. F, my lord. Because the learned court below have failed to appreciate the ratio laid down by the Honorable Apex Court in case of M. Ravichandran versus Intelligence Officer, Director of Revenue Intelligence, wherein it was held that the right to be released on default bail continues to remain enforceable if the accused has applied for such bail, notwithstanding, my lord will mark that, notwithstanding non-obstante clause, my lord, pendency of the bail application or subsequent filing of charge sheet or report seeking extension of time by the prosecution before the court or filing of the charge sheet during the interregnum when challenge to the rejection of bail application is pending before a higher court. Here, no bail application was pending before the higher court. There was a previous 2 bail occasions where my younger brother appeared, but the bail was rejected because the sensitivity of the case. But my lord, on perusal of the FIR and also the records that we have obtained under 161, perhaps, my lord, what I could conclude with this case is conviction will have a 0 rating in this case. So anyway, my lord, that I'm not going into the merit of this case. Or filing of the charge sheet during the interregnum when the challenge to the rejection of bail application is pending before higher court. In the instant case, my lord, charge sheet was filed during the pendency of the bail application number 35423 before the special court. Hence, the order dated 17/01/2023 is not sustainable in law and same is liable to be set aside and quashed for the end of justice. Now, my lord, for a moment, let us come to the impugn judgment or rejection order, my lord. Before that, my lord, I just I want to place 1 or 2 documents so that, my lord, kindly come to page 43, my lord. This is the record from the court below, my lord. Kindly come to serial number 103, my lord. Well, a type copy is at page, next page, my lord. Kindly come. Page 44. That it was called 102. It was called on 3rd, my lord, 3rd January. Meaning thereby, my lord, there must have been the process. And then finally, the charge sheet came to the learned court below by 3rd January. So, my lord, there is a gap of 8 days after I filed the default bail. This is one aspect, my lord. There is another piece showing the bail that we have filed. That my lord has seen at page 31. There is a stamp receipt also. My lord, kindly come back to page 31. My lord, we'll see at the left, there is a round seal of the court. The date of filing is shown as 26/12/2023, my lord. 2 incriminating documents of the learned court below, my lord. So now, my lord, the impugn rejection order But I'll start from this paragraph 3 is important, Milord. Page 46. That the police ought to have filed charge sheet within 90 days from the date of remand of the accused, that is on 24/12/23. However, no charge sheet has been filed by the police till filing of this present default bail application. That the mandatory period under section 167 clause 2 CRPC is already completed on 24/12/2023. Hence, the applicant prefers this bail application before this court under section 167 clause 2 CRPC. That the accused person is entitled to be released on bail, being an indefensible right of the accused under the first provision of section 167(2). So this was my contention before the learned court below, and learned court below have rightly recorded. Now, my lord, that two documents that I have shown. One is that the charge sheet was received by the Honorable Court, learned court below on 3rd January. And at page 31, my lord, is seen on the left side of the first page. It shows that on 26, I have filed a default bail. That is just after 2 days of the mandatory period. But 5th, there was no court, being the Christmas. And 26, the learned presiding judge did not preside at the court and proceeded on leave. Okay? Yes, it was on leave. Then finally, this matter was taken up on 17, in between the court holidays. So, Milord, therefore, this particular thing, the para 4, Milord, I have said that I have deemed to have able the thing, para 4. Then that earlier bail application which I have referred to, Milord, is at para 5 of the impugned rejection order 3/11/2023 and on 8/12/2023, Milord. Then I would, that normal summation. Now, Milord, my contention starts on the learned court below was about to proceed with taking cognizance. I said, no, my lord. I said, no, your honor. The law is well settled. Once indefensible right of an accused is able by filing 167 clause 2 bail, default bail, then this default bail, my lord, it can be either in the form of written application or if not, even on the oral submission also, my lord. That is what the Ravindran case has been dealt with. So then it was immediately brought before the notice of the court. The court ought to have appreciated that count also. Then I have relied on this judgment, my lord, that even this Ravichandran judgment, my lord, the latest judgment that was reiterated in the Jigar Elas, Jimmy Ravichandra Ajate, 2023 6 SSC, my lord. That particular, then I relied on. But then, my lord, what had happened, that Nirmala Yadav judgment is by a 2-bench judgment. Now this M. Ravichandran is by the 3 judgment. Whatever law laid down by the larger bench has to be followed. Then subsequently he has come to this. Anyway, my lord, then paragraph 9 is the contention advanced by the learned public prosecutor on that particular day. So these, he has quoted this Nirmala Yadav, my lord is aware of this, I need not to reiterate. Then, my lord, the 10 is the counsel for the victim who was assisting the learned public prosecutor in the learned court below, my lord. He says, so and so, for the complainant submitted that the learned PP does not need to file any application for extension. My lord, that particular point, I raised that question during course of my submission. I said, Your Honor, mandatory period has come to an end. If the learned public prosecutor seeks an extension of the time, he ought to have filed an application seeking extension of the time that my lord knows. So that particular procedure was not followed. Then when I made the submission, then from a slumber sleep, one of our colleagues, she came up and says that the learned counsel for the complainant submitted that the learned PP does not need to file any application for extension of time, as the charge sheet has already been filed on 3/1/2024. My lord, kindly mark this. It is on record, my lord. It is on record. It has been brought to a judicial notice that charge sheet came before the learned court below on 3rd January 2024. So then, then, my lord, then N, the instant bail availing default provision has been filed on 5/1/2024. This is a wrong submission, my lord, whereas I have already demonstrated, my lord. Now, this particular paragraph has been considered by the learned court below and curtail my indefeasible right. Kindly come, what is the finding, my lord? Para 11. After hearing all the learned counsels, this court perused the case record and court observed that in the instant case, the learned SPP has not sought for any extension of time for filing charge sheet as has been stressed by the learned PDC. It is not felt necessary, my lord, kindly mark this. How the learned court below has faulted. It is not felt necessary also, as the charge sheet has already been filed before bail application was filed. I am talking about the default bail, and the learned court below is talking about the regular bail application. With great respect, my lord. Further, any court release the accused person on its own motion if the accused does not file any such application for being released on default bail. Again, contradictions, my lord. In this case, it is seen that the accused has filed this application availing default bail. Now, again, another confusing statement coming up. Default bail, after the charge sheet has been filed. Now, my lord, kindly see, there was absolutely no application of mine. As I have already indicated in page 31, my lord, I have filed my default bail on 26/12. How this can be sustainable to curtail the right of the petitioner in this manner? Now, para 12, my lord, I'll not read all those things, my lord. Kindly come to last operating portion. Therefore, taking into considerations the fact that the IO of the case has already submitted a charge sheet before filing of this bail application, and the accused has proposed to avail his indefeasible right of default bail only after filing of charge sheet, this court is not inclined to grant bail to accused person on default. I am sorry. Kindly one more paragraph, Lord. The judgment which I have referred to has not been properly able to distinguish by the learned court below. This, that Sanjay Dutt judgment was also relied on in this. This two paragraph I will read. I am sorry for that. Paragraph 50 of the impugned law, page 48.
Page 40.
8, 48. 48.
Para?
Para 15. These are part of that Ravichandran judgment. Lord. These are all reiterated, but for brevity and clarity. Lord. Further, it is para 14. Lord. Further, it is found that the case of Jigar, alias Jimmy Ravichandran Aditya versus State of Gujarat, 2023, 6 SSC 484, as placed by learned PDC is not found relevant in the instant case. Lord. That I will distinguish, Lord, because this is not the correct proposition which the learned court below had concluded. Not found relevant in the instant case, as the state case deals with extension of time for investigation. It is not the case of time for. And in the instant case, no any application for extension of time for investigation has been put up by the public prosecutor, as there was no necessity, the charge sheet having already been. What is the requirement under law under 162, my lord? First, let us try to appreciate the legislative intent. The legislature has incubated that particular section, making it as a mandatory right. What? That falls from Article 21 of the Constitution of India. Therefore, this statutory provisions 162 has been imbibed in this particular act. One. And number two, my lord, had there been a no statutory provisions in the form of 162 by the court itself, then I do not have any right to apply the default. The law says that a particular authority is required to do a thing in a particular manner. But if it is done opposed to the law, it is not sustainable, because that will result into the miscarriage of it. In the instant case, my lord, from a side, from the records that I have adduced, my lord, the learned court below has faltered to. And any other thing, my lord, that Ravichandran, I can place it, indicate the paragraph and submit it. So therefore, like, Jigar. In this, my lord, I'll indicate the paragraph and yes, my lord may kindly indicate. My lord will have Ravichandran judgment first, my lord. Just on the proposition, my lord, the beauty of 167 is what from my understanding I have noted down is 167(2) in legal parlance is known as default or a compulsive bail. That was coming to my mind. The compulsive means compulsory, being a statutory right for the accused. My lord, paragraph 10.1 is the definition or the concept of what is right of the accused under 167. My lord, we'll just write it down, my lord. Then para 11, my lord, of this judgment says, after mandatory period, magistrate has no power to remand the accused. This proposition will come in my opinion. This was not properly appreciated. My lord, paragraph 16 to 17.1 and 2, my lord. It talks about the proposition of law on the fact that 167(2) is a fundamental right to life and personal liberty. So this cannot be overridden. 25.1. Once the bail application is, default bail application is received, it has to be heard first. Then 25.2 is the right to release on default bail continue to be enforced. Then below that paragraph 18.8 and 18.8 and 18.9 and 9, my lord. This Uday Mohanlal Acharya case was relied upon, my lord. Then paragraph 22.7, Nirala Yadav, my lord. Then 22.2 and 22.3. Now, my lord, meaning of what is availed or availing of the default bail. It is at paragraph 18, my lord. Para 18, yes. Now, paragraph 19 says 167 clause to CRPC is a fortified of right to default bail, my lord. Now, paragraph 20, my lord, it talks about PP can resist grant of bail. However, no extension shall be granted without notice to the accused. In this case, once the mandatory period is over on 26, and the charge sheet was filed on 3rd January, then and there the learned public prosecutor ought to have filed a notice application and put me on toes that, look, I need the extension of the time for this particular purpose. This proposition of law has also not been appreciated by the learned court below in the impugned. Now, 20.1 is also, my lord, default bail and application of extension prior to filing of bail application. Now, 20.3, my lord. Suppose sometimes what happens in the lower court, my lord, sometimes the learned public prosecutor, they try to mispress the direction of a button. Then this is not permissible. That is at 20.3, my lord. Then, my lord, paragraph 21 talks about how charge is to be filed and cognizance has to be taken in this case. I kindly appreciate that. Then that 22.4 is important, my lord. Default bail is made on expiry of 90 days, not even writing before, not even before filing of charge sheet, the right to default bail becomes effective. So here, my lord, from, my lord, 24 midnight, my lord, 24 midnight, I accrue the right of default bail, my lord. You know that I am fond of doing research. Then, well, that kindly come to Jigar judgment, as I indicated. That Balad will kindly see paragraph 36 to 42. This talks about the reiteration of the principle of law by in M. Ravichandran. Then extension of there are twin requirements like paragraph 43. Milad. What are the twin requirements, Milad? If my lord permit me, may I read it out, Milad? Paragraph 43. Milad. It says, Milad, the requirement of a report under the proviso added by subsection 2 of section 20 of 2015 Act to clause so and so is twofold. Firstly, the report of public prosecutor, the progress of investigation should be set out. And secondly, the report must disclose specific reasons for continuing the detention of the accused beyond the said period of 90 days. Therefore, the extension of time is not an empty formality. The public prosecutor has to apply his mind before he submits a report, an application for extension. The prosecution has to make out a case in terms of both the aforesaid requirements, and the court must apply its mind to the content of the report before accepting the prayer for grant of extension. As my lord has seen, nothing has been made mention about this. And these are the paragraphs that I have relied on. So, that paragraph 44, 45, these are all extension of the times, Milord. I'll not stick to up to 51, Milord. Then paragraph 51 to 55, Milord. The principle in the M. Ravichandran is reiterated. Therefore, Milord, my respectful submission is, Milord, apparent on the face of the record itself, Milord, kindly really direct authorities to.
May it please your lordship. Your lordship, it's a very simple issue actually, your lordship, because the law of default bail is very clear now, your lordship, right from the Sanjay Dutt matter. Your lordship, once the period of investigation, that is 90 days for this offense, life imprisonment, the question of extension doesn't come at all, because in NDPS there is a provision, your lordship, section 37, wherein it has a non-obscenity clause, 180 days, then 365 days. In such cases, your lordship, question of extension come. Here in this case, question of extension is not an issue at all. So I will not argue on that. Now, your lordship, the issue here is, only simple issue is whether during the pendency of filing of the charge sheet, whether there was an application for bail or not. That is the only issue, your lordship. If he has filed after expiry of the this mandatory period, and in the meantime, the investigation authority failed to file the charge sheet, then it will be considered that he has availed his right and he is entitled for right of default bail, your lordship. So now, your lordship, the issue here is, your lordship, otherwise everything is clear. So far as my senior counsel is indicated in a column also, your lordship, that he has filed an application on 26th for default bail, Your Lordship. So no doubt on 24th midnight, 90 days has expired, Your Lordship. Now Your Lordship may directly come to the order of the learned court below, because this will reflect the record, Your Lordship. So Your Lordship may directly come to this Tera, Your Lordship, 11, Your Lordship. Tera 11, Your Lordship. Whether during the pendency of the filing of the charge sheet, whether there was any application or not. If there was an application, he is no doubt entitled. Now, Your Lordship, may I read, Your Lordship? After hearing all the learned counsel, this court perused the case record and court observed that in the instant case, the learned special PP has not sought for extension of time for filing of charge sheet, as has been stated by the learned defense counsel. It is not felt necessary also, as a charge sheet has already been filed before the bail application was filed. Further, any other court cannot release the accused person of its own motion if the accused does not file any such application for being released on default bail. In this case, it is seen that the accused has filed his application availing default bail after filing of the charge sheet. Now, this is the only issue, Your Lordship.
Right.
And to find out, record is required. Because whether the application was filed before the filing of the charge sheet or not, because now this is disputed now, Your Lordship. They are saying they filed prior to the filing of the charge sheet. And as per the record, it says it was filed after filing of the charge sheet. If charge sheet is filed prior to the, Your Lordship, filing of the availing the default bail, then his right is extinguished, Your Lordship. So now only this issue has to be addressed, that whether it was filed prior to the filing of the charge sheet or not. Only this much issue is there, Your Lordship. So a record may be called for, Your Lordship. A notice has to go, because this is a criminal revision petition. The notice has to go to the victim, Your Lordship. It is not clear on the record, Your Lordship, because of the order of this court, the learned court below.
No, my lord, what my brother has pointed out, I have already demonstrated from the record of the court below only, which I have obtained through certified copy. My lord will
Have
pass.
you any notice to the respond number 2?
No, my lord.
This is motion
It's a
stage.
motion.
Motion is
Yeah,
stage. Your
I
Lordship.
agree.
Also matter, I think.
Yes, Your Lordship.
My lord, what had happened in the FIR, my lord, if my lord see, sometimes it is, I have all the records. The first allegation is at 10 a.m. in the morning, and after the IO is changed, the tutored version is 4 to 5 p.m. Now 4 to 5 p.m., I along with my spouse was working, cultivating in our kitchen garden, and head of the department and another independent witness was also there who have seen me. So something, Milon, I am not prejudicing the right of anyone here, Milon, but I am of the considered opinion, Milon, as a humble human being, Milon. There tends to be a gross misuse of POSCO 8, Milon. And yeah, that is, and another thing, Milon, they have also, even the charge sheet was also not completed in terms of their record, that they have written to the Google USA saying that the accused has been browsing those nude pictures. So therefore we need to see. From there, what they want to establish, I don't know. Milan, on record, Milan, I say, if these can be made as a
Let's forget about the merit.
Yes.
Yes, Your
Come
Lordship.
to the
No, but I-
question of whether default bail is entitled or not.
Yes, Your Lordship.
As per the order, from the order, it seems that the learned court below is stressing that the charge sheet was filed prior to filing of your charge.
Yes, Your
default bail application.
the record says
That
otherwise.
has to be seen.
Yes, Your Lordship.
Otherwise, you have seen that third of
Correct.
is there, but the question is another date is I have seen that it is FIR or the charge sheet was filed at least on 21st of December. So that is there in the record. So let us find out.
Only thing, my lord, consideration would be communication will not be the date of receiving of the documents of the charge sheet. It has to be from the date of placing before the
Before the court.
before the court.
Yes, that is there. And
So,
your
but
lordship,
here, that my lord has seen that particular thing. I came prepared for that. Well, kindly fix it on.
and your lordship, even if it is not a POXO case, in criminal revision, as per Guwahati High Court rule, notice has to go to the victim, your lordship.
Well,
Notice has to go.
29, I'll take Dusty service because the counsel who was appearing is a part of the family member of.
Dusty service is not permissible, your lordship. It can be served through your lordship, jurisdictional PS, your lordship, because your lordship very clear, it's a dispute, your lordship, and how the
Today,
court will allow them to meet them personally, your lordship.
29 is sufficient, my lord.
Yes, 29 will be sufficient.
Sufficient. It's nearby only. But here, the basic
Notice
I-
has to go, your lordship. Notice
Well,
has to be.
So
Oh.
where the person stays where?
Hey, Doimok, my lord.
But your lordship, after your maybe 2 weeks, your lordship, the notice has
2
to.
kilometers from here, my lord.
Huh?
2 kilometers from here.
He cannot go directly because Dusty service is not permissible. It has to be sent through jurisdictional PS. But
then
even
I'll
if your lordship, the matter is fixed on 29th, if notice is not served, again it will be refixed. No issue, your lordship.
That is not an issue, my lord. That we can resolve it.
And record has to be called for record.
So as per you, we didn't fix it. That should be fixed on.
29.
Okay, your lordship, if it doesn't come again, we'll take. We
Because,
have,
my lord,
That
See-
will be another issue.
Yes,
So
your
it
lordship.
will be on 31st or 1st of February, will do?
yes, your lordship. 1st of February, then your lordship.
It will be on 1st of February. Thursday.
because my lord, this is a question of default bill. Actually, we are only questioning the correctness of the order rendered by.
First of February. 2 days they will get another case.
Let everything, your lordship,
Well, let it be on.
goes in
31st,
one go, your lordship. Dispose of in one go.
31st.
So matters have already been fixed most probably. In the division bench also.
I
It
was
will be on
requesting
first.
my brother.
First. It will be-
Yes, first, your lordship, no
First,
issue. your
yes. And my lord, kindly, I'm requesting the learned public prosecutor he should expedite and request the police to deliver because it is.
Let them take steps first, your lordship, then we'll see.
I'll do it right now.
Secretary General, Dewan Council for the Petition, and also had Mr. DHA, the valid additional people, every one have to state this. This is an application, section 27, write all this. fine, yes.
Do it now.
After hearing the submission of submission made by the Learned Council for the petitioner appellant, the Learned additional people have submitted that this is a case under the POXO Act, so notice has to go to the respond number 2 as victim of this case. And also the record will be required to see as to whether the application for default bail was filed prior to the filing of the charge sheet by and let notice be issued to the respond number 2. To the through the jurisdiction PST related to the now this you have to
Dusty is not
keep it
permitted.
through PP, na?
Yes, your lordship, they will take steps through registry. Registry will forward it to us. Then we'll send it through jurisdictional PS, your lordship.
This is.
And through the public
Alert.
prosecutor, office of the public prosecutor. But this is the new, I don't know why it has been implemented, but presently the through registry and again to most probably office of the PP and then it has to go.
Yes, your lordship. We'll, usually we send WT message, then they.
Yes.
Yes.
Well, my lord, our
Also
system,
call for the scan copy of the yes.
our system, my lord, we have a channel called proper channel. And this proper channel is the longest channel in the world. So thereby justice are being
But,
drilled.
this time they will, it will not be most probably you take step immediately today itself.
I'm taking
and
right now.
registry-
Yes, your lordship. It won't take much time, your lordship.
Process notice and notice may be issued to the registry and the no like so
It's a procedure,
procedure.
due process. Well, just. that,
LCR, your lordship.
The LCR may kindly.
Copy of the
Yes, I have.
Call for. Then, well, that Google requisition which they have sent is. So I'm saying that, my lord, just please don't mind me. Just I'm saying 90% of the main will be behind the jail, my lord. if those records are delivered, because everybody, all the male person, they browse it. By chance, by default of the website browser, it comes.
Your Lordship, this
So
is
they
off
have-
record, Your Lordship.
So that is, they, no, they have brought it also, Milord. In the church sheet, they have written. So that is not out of it, Milord. Great, Milord.
Oblige, Your Lordship.
Yes, my lordship. This criminal petition is on merit, lordship, first of all. This, during the course of this investigation, this investigating officer has failed to make out any case against the accused person on prima facie. And this search sheet has been only filed and based on the 161 statement of the accused person, which cannot be treated as evidence. This is the only based on this accused person. And kindly this lordship, this
Started under which section?
search sheet under this lordship. What is
457 and
theft
380.
case? Yes,
457.
And 380.
457 and 380 theft case. In this case, the allegation is that lordship, kindly say, may I take your lordship to the FIR? Kindly see the FIR first of all. In the page number 13, annexure 1, FIR to the OCPS Longding. FIR against an unidentified culprit, that is theft, who broke into WPCA office and had taken
See,
two
the
almirah.
section itself is very relevant that if it is come under 457 and 380,
Yes,
obviously, who will see there?
Yes.
And unknown culprit will be there. During the investigation or during the stage of
Yes,
investigation, most probably that has come out.
Yes.
That these two accused persons may involve in it. Is that much?
first of all, then lordship, kindly see. Allegation is against the unidentified person,
Definitely.
number one. And during the course of investigation, the IO of the case has said, I have recorded under 161 of CRPC, they have admitted the committing of it. Whereas lordship, kindly see, page number
That is the-
16.
That is the only reason you have come
Yes,
to.
yes,
cause
page number
proceeding.
6, yes, kindly see, page number 16, annexure 2-3.
No, that is the only reason you have come with a petition that it is.
Yes,
It is a petition for quashing the FIR.
yes,
criminal
that is,
proceeding.
then lordship, at the time of
You know,
framing
the-
church lordship, framing church lordship, the court has heard the church charges in page number 23, annexure 5, in which lordship, they have taken cognizance, lord. We have made an objection before the authority, that the trial court, that there is nothing, any sufficient material to frame church against the accused person.
Obviously, the
That's
time
part
of
of the
hearing of
fact
the
that-
charge, you have the right to raise objection. But
Kind-
probably prima facie case was there and that is the reason why the charge was failed.
Kindly see, lordship,
Okay, then issue notice.
page,
Yes, issue notice, Your Lordship.
page, may I lordship, page number 16, kindly see. Page number 16, annexure 3, what's the
21.
circumstances under which the seizure memo has been issued, Lord. That says, on being shown by the complainant party, 500 meters away from the place of occurrence. That is the issue. Whereas the police investigating officer has said, this is on the disclosure of this accused person. Whereas there is nothing, any record to show that on the basis of disclosure, as per the CRPC, that has been recovered, stolen property has been recovered. And when, as per the 162 CRPC, 161 statement cannot be evidence, and there cannot be a ground for proceeding. 161 statement cannot be a ground for proceeding against accused person. That is why I am praying for lordship, suspension of proceeding.
Also hard state. PG Dinani traditional people obeying the behalf of safe respondent. It's an application, section 22 in connection with strange. Issue notice. to the respondent. However, the respondent, no notice is to be required to issue. The respondent number one, as the judicial people has already appeared. Appears in this case. You give the copy during the course of the day and issue notice to respondent. Also call for, you want to the case record?
Yes, Your Lord.
Also call for the scan copy of the case. Let the matter be instructed after 2 days.
Interim order may be passed.
I don't think so. It is a big case to pass an interim. It's a case and a situation. Let the matter be. We'll see.
On next date, Lordship,
Yes.
hearing for interim order may be heard, Lordship.
By the way, you take
Yes, the
steps
record may
first.
be called for, and
First you
when the
take
record
steps on
comes,
respond number 2 also.
yes, let the record, on that particular observation be made, Lordship. When the,
In fact, if that observation has to be made, Your
Other-
Lordship will say
other-
that there is no ground even for the interim, Your Lordship. If I'm to
without
argue
interim,
on
Lordship,
not
I-
granting the interim, Your Lordship will see in the charge sheet, Your Lordship, it's up. When he has pointed out where the stolen cash amounts were, that's when the recovery was made, and under 27 of the evidence is clearly, there is a clear case
It is-
against him,
it
Your
is
Lordship.
not-
There is no ground for interim. In fact, the interim
Lordship,
prayer may
Lordship,
be
today-
rejected today itself.
This honorable
Maybe
court,
heard,
if this
I-
honorable court
Yes.
is ready to hear.
On receiving the LCR, Your Lordship. Scan.
We
On
hear
next
that
date, Lord.
prayer for interim may be heard.
Here, that way.
The prayer.
May I please, Lordship?
Yes.
Lordship, this is a pre-arrest bail application filed by the applicant Sri L. Okendro Roy for granting of pre-arrest bail in connection with 0 PS case number 1/24 under section 420/406/34 IPC. Lordship, here in this case, the only non-bailable section is 420. 406 is compoundable and bailable in nature. Lordship, here in this case, before going to the FIR, I would like to highlight the basic facts which lead to the filing of this FIR. Lordship, here in this case, the complainant Sri Hagebat of a resort called Zero Valley Resort. And the applicant accused person is the general manager, and he has taken on partnership or lease from the owner or the complainant for running the said resort, Zero Valley Resort. So, Lordship, basically the dispute between these two is civil in nature, as because without any reason, the accused applicant has been fired from his job of managing director by the complainant owner. But when the applicant was about to run the said resort, he has deposited rupees 25 lakhs to the owner or the complainant. And in between, they have made a verbal agreement and assurance that when you discontinue the said resort, you take back your 25 lakhs. In respect of that verbal agreement, the complainant has given 3 leaves of check. Complainant has given 3 leaves of check to the accused person applicant. As such, when he was fired from his job, then the accused person has withdrawn rupees 7,35,000, which is clearly reflected in the FIR also. Now I'm coming to the FIR, Lordship. To the officer in charge, Police Station Hapoli. dated 11 January 2024. FIR against Sri L. Okendro Roy, ex-General Manager of Zero Bailey Resort. Sir, this is to inform you that one Sri Hamong Purandar of Impal has fraudulently withdrawn rupees 7,35,000 only from the current account number so and so of Zero Valley Resort from the SBI branch All Zero branch yesterday on 10th January 2024. I was shocked to receive a message from the bank that the said amount has been withdrawn without my knowledge and permission by the person unknown to me and having no any business dealing with him whatsoever. I strongly suspect the involvement of Sri L. Okendro Roy. He is the applicant accused in this present bail application. Ex-General Manager of Zero Bailey Resort. As the checkbook was under the custody and the checkbook number so and so by which the amount was withdrawn was found missing. When he returned the checkbook on 8 August 2023, after dismissing from the service in the month of July 2023. Lordship, at this point of time, I would like to pause for some time. Lordship, here in this case, the complainant, he himself has stated in the FIR that the checkbook was given to the accused person. So when the checkbook has been already given, it is not the case that the accused person has forged the signature. It was post-dated check with a agreement that when you discontinue this Zero Valley Resort, you take away your already deposited rupees 25 lakhs. So yes, written is there. I have annexed that, but there is no signature. Written agreement was written with his own handwriting by the complainant himself. So this is the case. In this case, it is fact that I have not withdrawn the case as because I have no SBI account number. So I engage H. Purandar, who is my friend. He has withdrawn the amount, but on my instruction, as because the instrument, the check was already given to me by the complainant with the agreement. May I take Lordship to page number 25 of my bail application. Page number 24 is the original copy which was written by the complainant Sri Hagebad, and page number 25 is the typed copy. May I read? Decide to authorize Okendro Roy, who is me, the applicant accused person, my present general manager of Zero Valley Resort, to run public manage the catering services, including the bar plus A block building consisting of 6 rooms for 5 years with effect from 1/3/2023 at lease of rupees 1,50,000 only per month for a period of 6 months, March 2022 to August 2022, and rupees 2 lakhs only per month with effect from 1/9/2022. The monthly lease rent shall be received after 3 years, that is 1/3/2025. Security deposit of rupees 25 lakhs shall be done within 6 months from 31/1/2021. Entire expenditure, including staff salaries, electricity bill, water supply bill, maintenance of the property, standardization of service, updation of facilities on need basis, etc. This was the written given by the complainant to me. So I have deposited rupees 25 lakhs. And when he fired me in the month of July 2023, without any reason and notice, so I have withdrawn this said amount. In fact, Lordship, in order to prevent me from withdrawing my deposit of rupees 25 lakhs, the complainant has filed this FIR. This is the fact of the case. So, Lordship, this is civil dispute in nature. I may be given protection.
Yes, Your Lordship. The reason is mentioned in the FIR itself why he was terminated, Your Lordship. In earlier occasion also he has cheated the owner, Your Lordship, and misappropriated amount of rupees 44 lakhs, Your Lordship, in page number 18. Your Lordship. Perhaps at this present, Your Lordship, it can be presumed that earlier also he has committed an offense, Your Lordship. Your Lordship may kindly come to page 18. Further, when he was, Your Lordship, working as general manager, he had cheated and misappropriated an amount of rupees 44 lakhs 72,423. Your Lordship. Here, this is means the earlier incident. And in present, Your Lordship, the check was with him. Your Lordship may find in para 3 of the FIR, Your Lordship. I strongly suspect involved of Sri so and so, ex-general manager of Zero Valley Resort, as the checkbook was. That means it was in his possession earlier, Your Lordship, wherein he has taken out some leaves from the checkbook, Your Lordship. So, Your Lordship, for that LCR has to be, Your Lordship, perusal FIR, LCR, CD is required, Your Lordship. And his prima facie case is made out against the accused for under, Your Lordship, section 420, Your Lordship. Because he is not employed there now, Your Lordship. Earlier he was employed, but after termination again he has committed the offense.
May I further, Lordship, may I submit? Lordship, regarding the allegation of cheating of rupees 44 lakhs 72,000, he has not substantiated anything. It is just said in the earlier occasion. Now the case is with regards to rupees 7 lakhs 35,000, which I have withdrawn. And there also, as I have already submitted, that it is the security deposit of rupees 25 lakhs, which I have already deposited with the complainant. Lordship, here in this case, at most, the allegation is 420 in IPC, 420 IPC, which is non-bailable in nature. Lordship is well aware of the Supreme Court judgment 2014, Ernest Kumar versus State of Bihar. Here in this case, the Supreme Court has clearly stated that when the punishment is up to 7 years, the police may not arrest the accused person. Rather, the accused person may be issued notice under section 41A of IPC. But here in this case, the case is of economic offense. It's of civil nature. But on the behest of the complainant, on receipt of the FIR, suddenly the police has registered the case only to harass me, Your Lordship. So I may be given protection till the returnable date.
Ernest Kumar will not be applicable for the court, Your Lordship. It is applicable to the police, Your Lordship. And now he is approaching this court invoking 438, Your Lordship. It is not after issuing of the notice. He has not given the investigation authority an opportunity to issue notice, Your Lordship.
Lordship, I am married to a local Apatani girl at Zero, but police has never issued me notice. So I may be given protection since the case being civil in nature, Lordship. Titaba, Lordship.
It's an application, a section mentioned in connection with submitted by the Land and Council for petition that the accused is not involved in the case as alleged in the FIR. However, it is a fact that the petitioner was an employee and working as a manager in the in the, what was the name? Did we state?
It's Zero Valley Resort,
Valley Resort,
located at Zero.
located at Zero, which under the complainant discussed in court. However, he was fired from his service on July 2023 without any notice and without any notice. While he was working as a manager in that resort, there was a verbal agreement that, and accordingly, he deposited rupees 25 lakhs as security deposit. And in that context, the complainant also issued some checks in his favor, and it is a precondition that whenever he leaves the job, he will be entitled to receive back the security deposit money. As the check was in his possession, so accordingly it is a fact that he withdrawn an amount of 7,50,000 from one check, and the complainant only to restrain him from withdrawing the other checks, filed the present petition with some forms and proper text. The dispute is between this is dispute on the FIR itself. It is seen that dispute is of civilian nature, and the petitioner is ready and willing to cooperate the item in the further investigation of this case if he is granted with the privilege of interim privilege.
$35,000.
Further, he will cooperate the item for the investigation of this case. Considering the submission made by the Government Council for the Books and also considering the entire aspects of the case, I am of the view that this is a case where the petitioner can be granted with the privilege of interim 3 years bill, the receipt of the case data. Accordingly, we will make other submissions. We will be under interim.
Deeply obliged.
Yes, all directions will be there. And
Yes.
CD for CD will be there. There will be some direction, but by all the conditions.
Lordship.
Deeply obliged, Your Lordship.
Deeply obliged.
I think the opposite side is on his legs in the other court. Matter may be taken up for some time. Yeah.
Please, Your Lordship.
my learned brother raised a objection regarding the mentality of this revision petition. So we may take some time to lodge it. This is regarding the criminal revision.
Earlier occasion, you have raised some objection regarding the major.
Yes, earlier occasion lodge it.
Oh,
Even without filing affidavit and even without calling for the LCR, because Lordship, settled proposition of law is that such type of order that is impugned in this revision petition, Honorable Apex Court has held that this is intellectual in nature and this is barred under section 397 subsection 2. So basically, I'll be placing some judgment.
what you do?
Yes, I have also some citation. I will also, I will take some time. Lodge it. You can start or
Oh,
we
today
can.
you are going to
Yeah,
submit?
today, yes,
Okay.
today we can.
Okay.
Now, I will start. So, for the combination.
So, against which order or deliver what
Yes,
order you have come?
Impugned order is at page 81.
81.
Yes, 81.
This is the
May,
order.
may I read out, Lordship? This interview?
Pardon?
May I read?
Hi, yes.
The case is taken up for hearing IA number 6/23 in RMGR case number 9419, born out of the Sangam PS case number 7. Accused person Taku Takum, Toku Punu, Toku John, Toku Rana, Toku Thomas, and Toku Taba were present and represented by Leonard DC Mba. Seen that the dispense application for Toku Tadam has filed citing vision, various and allowed. Mr. B. Tayo, Leonard APP is present and assisted by Leonard Counsel for the victim, K. Tama. The instant IA has been filed under the section 91 CFPC for directing the sexual officer Palin Karandadi to produce the original document which is in the report dated 28/4/2017, which has been exhibited as E-Exhibit 1, signed by the 7 arbitrators middlemen in the mail between the Tuner and the Taku clan at the helipad ground Palin. Leonard DC has submitted that one of the arbitrator middlemen, Sri Donik Tadu, who appeared before this court and deposed at the DW12, stated that he had never put any thumb impression on any report, and further perusal of the case record reveals that DW2 deposed before this court that instead he put his signature on documents and not merely put his thumb impression, and that the thumb impression against his name in deed exhibit number 1 has been forged by someone for miscarriage of justice. The learned DC has further submitted that the deposition of DW12 against the alleged thumb impression in D exhibit 1 warrants the intervention of this court to verify the genuineness of the D exhibit 1. Otherwise, it will be prejudiced to the accused applicant. The learned DC further submits that with that regard, DW12 has already lodged a complaint before the Palin police station against the forgery of his thumb impression in the D exhibit 1 dated 28/4/2018. Mr. K. Tama, learned counsel representing the victim, with the permission of the court, submitted that the issue raised by the learned counsel in IA 6/23 in RM number 94/19 is completely a different matter than the issue at hand. The learned counsel K. Tama further submitted that the instant case being the RMGR 94/19 is on the issue of the whether the accused person had committed the offense which has been alleged against him in case, and issue of the forgery of the thumb impression is nothing but delayed activity of the defense. It is further submitted that the deposition of DW12 in itself has anomalies regarding the number of the arbitrator middlemen who were appointed by the learned Deputy Commissioner Karandadi for the mail between Tuner and Taku clan on 28/4/2017, and further deposed that the order dated 27/4/2017 passed by the DC Karandadi was in fact in continuation of order dated 4/4/2017 and not in superstition. I have perused, I have heard the respective counsel in details and also perused in IA number 17. The question before the court is whether the prayer of the learned DC for directing the DC Karadadi to produce the document and to send the same for examination by the forensic handwriting expert is required for proper adjudication of the iron numbers and so, and coming to the judicious conclusion. Perusal of the record reveals that the instant trial is for the whether the accused person, namely Toku Takum Toku so and so, and Toku Tadam destroyed the plantation of the victim as alleged, and this court fails to understand the correlation between the finding out whether the signature of the DW12 and forged on Exhibit 1 and alleged destruction of the plantation of the victim in the instant case. The learned counsel for the victim has rightly pointed out that the issue raised by the learned DC is a completely separate issue than the one in the instant case, and if any, there are different remedies for the DW2, which the DW2 has already taken recourse to by lodging the complaint before the police station as informed by the learned DC himself. Section 5 of the Indian Evidence Act speaks about the evidence being given facts which are in issue and relevant facts. This court neither does find any merit in the submission made by the learned DC in IA numbers and so, and nor does find any relevancy in the allowing the prayer made in the IA 06/2023 for proper adjudication for and for the coming to the judicious conclusion in the GR numbers and so. Hence, this court has arrived at a considered opinion that the allowing the prayer made by the learned DC in IA numbers is not in the interest of justice. Accordingly, IA number stand rejected and dismissed. The accused person are present in form so and so on. And this was the rejection. Now I will show how this document is related. Because based on this document, the court has called where the state has not made a witness, those the arbiter and middleman. But in this case, after closing of all the prosecution witnesses, the court so moto called those arbitrators and made as a court witness. After examining the court witnesses, then additional offense was charged against the accused. Then again, after examining the another court witnesses, again, earlier there are 7 accused in this case, Lordship. And out of 7 witnesses, 3 witness statement recorded as per the provision of section 313 of the CRPC. There is some material evidence against those 3. But 4 were not recorded. But after examining these witnesses, the middleman and arbitrator, then another 4 accused whose statements were not recorded, again the court has recorded. There is so many development in connection to this lawsuit. Now, for convenience of this lawsuit, I prepare some, because I have not annexed entire order sheet of the proceeding lawsuit. So I prepared the list of documents for the now. Here, Lordship, just this is just one page. I will just yes, Lordship, kindly go to the list of documents. Just on the 3rd May 2021, Lordship, that charge under section 427/34 IPC was paid and dropped 188 IPC because they have not obtained the sanction. So 21 it was charge was paid, and 28 October 2022, Lordship, next number, court witness was examined. One of the court witness was examined by the presence presiding officer. Earlier, who has charged the accused, he has already transferred. Then thereafter, present presiding officer, he called a court witness. Then thereafter on 30/11, it was the prosecution was already closed the evidence, and it was fixed for statement of the accused lordship under provision 313 CRPC. And 10/12/2022, additional charge under section 447 IPC was framed against all the accused lordship. After examining the court witness, earlier only two offense, that is 427 and 34 IPC was framed, but later on, then after closing the evidence, then 447 was framed. Then, then thereafter, lordship, statement of the accused, 3 accused was also recorded under the provision of 313, but left out the 4 accused, saying that due to lack of evidence, lordship, so the court has not recorded the statement of 4 accused. Later on, again, another court has given a court witnesses on 4 March 2023, court witness examined. Then on 17/4/2023, DW examined and closed its evidence lodging. Then 17/4/2024, Somoto court again summoned those arbitrators, middlemen, as a court witness. Neither the prosecution has prayed any or submit any application, nor make a verbal prayer also, but Somoto called those, saying that they are related to this. And order sheet will, I think later on we will be required order sheet to produce lordship. Then not only the arbitrator lordship, this present presiding officer again called back the prosecution witness number 1, who is the informant in this case, and prosecution number 3 for re-examination. And they were re-examined later on. Then after re-examining and examining the other court witnesses, then lordship, the 4 accused statements were recorded on 19/6/2023 then lordship again, what happened, some of the arbiter still it was left out. And on 11/8/2023, then again on the prayer of the complainant, that is again court has summoned those arbitrators as a court witness, and the court were examined. And during that examination, lordship, one document which was, because before registration of this criminal case, the deputy commissioner passed an order, appointed some arbitrators and middlemen to conduct a mail to settle the land dispute case amicably, lordship. So on 11/8/2023, those arbitrators were examined. While examined, they have, when the mail was paid, so they have submitted report to the deputy commissioner or circle officer, lordship. And where they were, some signature or thumb impression was forged and submitted a false report to the CO. That's why, lordship, the accused has prayed the honorable court to direct the CO, circle officer, to produce the document, dispute document, because the middleman judges saying that this is not my thumb impression. I never put thumb impression. I used to sign in the any document. So, but court later on after IA saying that there is no any relation, lordship. This is the case now, lordship.
That IA was filed by DC.
No, yeah, accused, lordship. IA was filed by the accused, yes, lordship. So accused has filed the IA making prayer that the dispute document may be called for, yes, so that it can be sent to the forensic, whether, because one of the witnesses' signature was forged, and as very interesting, lordship, I will come one by one record also, lordship. Now, deputy commissioner has appointed four arbitrator oblique judges, it is mentioned there in their order, Lordship. But the report submit to the deputy commissioner or circle officer is by 7 middlemen or judges, Lordship, arbitrator. Last order passed by the deputy commissioner appointing the arbitrator is the only 4 candidate, Lordship, 4 members. But report submitted after when the mail could not be settled, the report submitted by 7 arbitrators, which is the dispute, Lordship. Now, now, Lordship, I will come to one by one, Lordship. Now, during argument, my learned brother saying that there is 3 orders issued by the deputy commissioner saying that that is not a supersession, but it is a continuation order. But now I will show you, Lordship, how it is a supersession order. Lordship, I will take you one by one, annexure 1, Lordship. Page 28, Lordship. Page, Lordship. This was because we are accused clan were the registered society, Lordship. So they are taking up for welfare of the entire public of the area. And the respondents, private respondent, they encouraging some public football grounds and then roads like that. So the accused has issued some notice to vacate those areas where they are encroaching. So, being aggrieved this notice, the private respondent lodged a complaint before the deputy commissioner. So, deputy commissioner, accordingly, the next page, Lordship, annexure 2, page 29, Lordship. Here, Lordship, the deputy commissioner appointed 5 village authorities, and their name are Kodatabang so and so. Then, of course, here they have not fixed the exact date when the mail has to be conducted, Lordship, but they were appointed this arbitrator and village authority. Then, next page, Lordship, annexure 3, Lordship. This is the first annexure 2 is the Lordship 4 April 2017 it was appointed. Then second order is Lordship 24 April 2017 come to annexure 3, Lordship. Come to annexure 3, Lordship. Here also 5 arbitrator was appointed. Now same person, Lordship. Annexure 2 and annexure 3. Arbitrator names are the same names. No any member was changed. Then in that case, when 5 members are appointed by the commissioner, then the accused clan, they have raised an objection saying that out of 5 members, 4 are related to the respondents, that is complainant side. So they request the deputy commissioner saying that you appoint some neutral person so that there will be no bias decision. So annexure 4 is that application that the petitioner has giving details of the region, how they have related, and some of the members are already having a land dispute with the petitioner's clan, Lordship. So there will be no justification for by conducting this member, there will be a biased decision also. That's why they have submitted this NHR 4. Now, finally, Lordship, on 27 April 2007, after receipt of our complaint, then Deputy Commissioner first appointed other arbitrators, 4 arbitrators, Lordship. Kindly see NHR 5, Lordship. This 4 arbitrators, we have no any objection. We're going to conduct the mail on 28th of April 2017, Lordship. Now, my learned brother said that this is not a superstition, but same person is appointing first time same person, then second time same person. How, if it is a continuation order, there must be some changes in the member also, arbitrator also, but same person was appointed. Therefore, it is a superstition order. And this, finally, this 4 arbitrator has to conduct the mail. This is the, on 27 April 2017, they nominated as arbitrator in the contents they mentioned or judges of the said case. They will conduct the, on 28th of April 2017, Lordship. And accordingly, what the party was appear, where place was fixed, the Paling helipad, name of the place, the helipad ground where the helicopter is landing, that ground they have fixed the date, and accordingly both the party appear. And from morning to till lunch, there was a mail was going on, and they have framed some regulation that while discussing the dispute, there should be no any quarrel or no such things would be happen. So this way they have prepared. And later on, after framing of some regulation, it was about to be 11:30 or 12. So the judges said that, arbitrator said that now you, both the party have a lunch, then we will continue the mail. Then both are left. Then after coming back the petitioners in the ground, but the complainant never turned up. And later on came to know that there some garden was destroyed by some unknown person. So they not going to attend the mail. And finally they have lodged a FIR. And that's why this criminal case was come. Then Lordship, now come to Annexure 6, Lordship. When Deputy Commissioner Annexure 5 appointed 4 arbitrators, and out of 4 arbitrators, 3 arbitrators were appeared, and they were conducted. One also missing, that Biri Kyoda, he was not present. And now, Annexure 6, Lordship, kindly see, this is the mail report regarding the land dispute. These are there are 7 arbitrators. Annexure 6, Lordship. Yes, page 33. There are 7 arbitrators. Where from come 7 arbitrators, Lordship? Deputy Commissioner has appointed only 4 arbitrators. And they have, in the contents, they have written that the petitioner's clan had destroyed their garden. They have submitted to the circle officer. And one of these arbitrators, that is Donitado, he said that I never put some preparation. Every time I used to sign before this honor. That's why, Lordship, I have the accused petitioner has asked the Honorable Court to direct the CEO to produce this, to examine how this report was, whether it is a genuine or is forged for miscarriage of justice. And if it is a genuine, supposed to be report to be submitted by those appointed by the Deputy Commissioner, not the other person, Lordship. And this is the case, Lordship, and thereafter, Lordship, then I will take your Lordship to the
Question is the impugn order, why as per you it is a revisional order,
yeah.
order to be released?
Yes, yes, Lordship.
Or as per
So-
the other objection raised by him that it is not at
Yeah.
all order to be reviewed or revisional?
Yes, yes, Lord,
So that
Lord,
is your-
yes, because,
Now, as per your submission.
yeah, in
That's
the
why,
context of the case,
that's
I
why
think-
Lordship, I was, for a moment, I was feeling like this is an appeal, not a revision.
no,
The
because
actual aspect.
the
Anyway, it is a
learned court
limited-
below,
limited issue.
Lordship, learned court below said that there is a no relation, because no relevancy. What the IA was filed, saying that no relation, but I'm showing this, there is a relation between this document and how it is related, because after examining those habitators, the additional charge was paid. Then 313 was examining, this is all a relation, Lordship. Now, anyway, Lordship, now I will show you. Because once it is rejected to call the document, it is amounts to a final order, because cannot be, later on cannot be, because what interlocutory order means, which cannot be a final order, Lordship. And now directly I will come to Lordship some citation then. Lordship, this is the Supreme Court in Rajendra Kumar, Sitaram Pandey and others versus Uttam and another Lordship. And relevant paragraph is page or relevant para 6 Lordship. Kindly come to page 136, para 6 Lordship. Discretion in the exercise of revisional jurisdiction should therefore be exercised within the four corners of the section 397. Whenever there has been miscarriage of justice in whatever manner, under subsection 2 of the section 397, there is a prohibition to exercise revisional jurisdiction against any interlocutory order, so that injury or trial may proceed without any delay. But expression introductory order has not been defined in the court. In the Amarnath versus State of Haryana, this court has held that the expression introductory order in section 397(2) has been used in the restricted sense and not in the broad or artistic sense, and merely denotes order of purely interim or temporary nature, which do not decide or touch the important rights of liability of the party, and any order which substantially affect the right of the party cannot be said to be an intellectual order. In Madhu Limaya versus the State of Maharashtra, a three-judge bench of this court has held an order rejecting the plea of the accused on the point which, when the accept will conclude the particular proceeding, cannot be held to be an intellectual order. In BC Shukla versus State, this court has held that the term intellectual order used in the Code of Criminal Procedure has been given a very liberal construction in favor of the accused in order to ensure complete fairness of the trial, and revisional power of the High Court or the Session Judge could be attracted if the order was not purely intellectual but intermediate or quasi-final. Now, here, Lordship, this by examining the court witnesses, and this was affected to the accused person. So this cannot be an intellectual order which passed by, though it is a pass in the intermediate stage, Lordship. This is the what the Supreme Court says. Then another Lordship, here, relevant, this is the case of Mohit alias Sonu and another versus state of Uttar Pradesh and another. And the relevant is page, paragraph 25, Lordship, 25. Page 805, Lordship. In the light of ratio laid down by this court, refer to herein above, we are of the considered opinion that the order passed by trial court refusing to issue summons on the application filed by the complainant under section 319 CRPC cannot be held to be an interlocutory order within the meaning of subsection 2 of the section 397 CRPC. Admittedly, in the instant case before the trial court, the complainant's application under section 319 CRPC was rejected for second time, holding that there was no sufficient evidence against the appellant to proceed against them by issuing summons. The said order passed by the trial court decide the rights and liabilities of the appellants in respect of their involvement in the case, as held by this court in Amarnath case and an order which substantially affects the right of the accused, Lordship, substantially affect the rights of the accused or decide certain rights of the parties cannot be said to be interlocutory order as to bar a revision of the High Court against the order or contemplate under section 397 of the law. That's why this order cannot be interlocutory. This is the then similar decision Lordship here also in the here relevant Lordship paragraph 8, 9 and 10. 8 Lordship. Bhaskar Industry Limited and so. Para 8 small para Lordship. The interdict contained in the section 397(2) of the Code of Criminal Procedure pursuant the code is that the power of the revision shall not be exercised in relation to any interlocutory order. Whether an order is interlocutory or not cannot be decided merely looking at the order or merely because the order was passed at the interlocutory stage. The safe test laid down by this court through a series of decisions is this. If the contention of the petitioner who moves the superior court in revision as against the order further challenge is upheld, would be criminal proceeding as a whole, culminate. If they would, then the order is not interlocutory order in spite of the fact that it was passed during any interlocutory stage. Para 9 also. 3-judge bench of this court in Madhu by Maharashtra laid down in the following so an order rejecting the plea of the accused on the point which, when accepted, will conclude the particular proceeding will surely be not an interlocutory order within the meaning of 397 subsection 2. This was upheld by the 4-judge bench of this court in B.C. Shukla and state through CBI. Now, para 10, the above position was reiterated in the Rajendra Kumar Pandey, which I have Lordship just in the first beginning I have some. It is a well-nigh settled that deciding whether an order challenge is interlocutory or not as a section 397(2) of the code. The sole test is not whether such order was passed during the interim state so and so and so. Lordship is similar. These all are similar, Lordship. No. And last one, Lordship. Here, relevant paragraph is 27, 29, and 30, Lordship. 27, 29, and 30. Uh, 27. While exercising its appellate power, the jurisdiction of the High Court, although is limited, but in our opinion, there exists a distinction, but a significant one, being that the High Court can exercise its revisional jurisdiction or inherent jurisdiction, not only when the application therefore is filed, but also suo motu. It is not in dispute that suo motu power can be exercised by the High Court while exercising its revisional jurisdiction. There may not, therefore, be embargo for the High Court to exercise its extraordinary inherent jurisdiction while exercising other jurisdiction in the matter, keeping in view the intention of the Parliament while making the new law for the emphasis of the Parliament being a case before the court, in contradiction from the person who is arraigned as an accused before it. When the High Court is seized with the entire case, although would exercise a limited jurisdiction in terms of section so and so under section, and the same in our considered view cannot be held to be a limited other powers, and in particular that of the section 82 of the Code of Criminal Procedure in relation to the matter which is not before it. Now 29, the High Court while thus exercising its revisional or appellate power may exercise its inherent power. Inherent power of the High Court can be exercised. It is treaty both in relation to substantive as also procedural matter. This is the Lordship decision of our Appeals Court. So, my humble submission, Lordship, the rejecting my IA, the revisions like Lordship as per the decision of our Appeals Court. So, my humble submission, the notice can be issued and called for the record. Because this was not admitted, so it is a matter condemned. That is my submission.
Yeah, please, Lord. Since, my lord, this is, we are in revision. Only the jurisdictional error committed by the learned trial court below, that has to be pinpointedly argued, not on the merit. Subsequently, what had happened, that framing of additional charge, that was not put to challenge by the petitioner in this case. Basically, only agreed because the application of the petitioners for calling for some document from the office of Deputy Commissioner Karadadi District, that was rejected. And despite of argument, by taking some time, my senior brother has not pinpointedly made out what is the relevancy of that document in that case. Learned trial court below has rightly observed that document, this is your document. You are DW, you brought DW 12. You got exhibited this DW number 1 document. And now you are disputing your signature, the document which you have exhibited, that is not prosecution's document. And now you are saying, again, this document has to be called for examination to before the FSL. So therefore, learned trial court below rightly observed that this is a delay tactics. And therefore, since this document has no relevancy with the case, that I have to decide in the present case, in the GR case, so therefore rejected your application. Now, so many judgments my senior brother has placed, but then those are connected to some other issues. Like, of course, I do agree if any order is passed in connection with section 319 of CRPC, or taking charge, taking cognizance, or framing charge. Of course, those orders, though they are intellectually order, but they are amenable to revision before the High Court. Those are the decisions that my senior brother has placed. But we are on the application that was rejected under section 91 of CRPC. So for that specific issues that is involved with this revision petition, kindly I have placed one judgment, 2009 5 SCC 153.
Yes, only. So earlier On earlier occasion, you filed.
Yes, I have placed there. No,
2009 5 SCC 153.
correct.
Page is here.
Paragraph 5 may be kindly. See. May I read the paragraph 5? Secondly, what was not realized was that the order passed by the trial court refusing to call the documents and rejecting the application under section 311 CRPC were interlocutory orders, and as such, the revision against those orders was clearly barred under section 397(2) CRPC. The trial court in its common order had clearly mentioned that the check was admittedly signed by the respondent accused, and the only defense that was raised was that his signed checks were lost and that the appellant complainant had falsely used one such check. The trial court also recorded a finding that the documents were not necessary. This order did not in any manner decide anything finally. Therefore, both the orders, that is one on the application under section 91 CRPC for production of document and other on the application under section 311 CRPC for recalling the witness, were the orders of interlocutory nature, in which case under section 397(2), revision was clearly not maintainable. Under such circumstances, the learned judge could not have interfered in the revisional jurisdiction. The impugned judgment is clearly incorrect in law and would have to be set aside. It is accordingly set aside. The appeals are allowed. So with this authority, Your Lordship, it is very clear that whatever order it is passed under section 91 of CRPC or section 311 of CRPC, those are interlocutory in nature. And for that, kindly come to CRPC. May I read subsection 2? Three 97, Lordship, it says, calling for recourse to exercise power of revision. So and so, High Court and Session Court. Now kindly come to subsection 2. The powers of revision conferred by subsection 1 shall not be exercised in relating to any interlocutory order passed in any appeal, inquiry, trial, or other proceedings. So interpreting this provision, Lordship, the Honorable Apex Court has held that any order passed under in section 91 CRPC or section 311 CRPC is interlocutory in nature and revision is not mandatory. One more judgment, Lordship, is because they have filed this revision petition even by invoking section 482 CRPC. Therefore, for the purpose of argument, in the course title they have mentioned an application under section 401 read with section 482 of the CRPC. Therefore, one judgment, Lordship, 2017-14 SCC 809, wherein the Honorable Apex Court has held, Lordship, kindly come to page 24, Lordship.
Para 24.
Para 24, Lordship. Page 831.
$821.
831 also. Para 24. The second reason why Amarnath is important is that it invokes the principle in the context of criminal law that what cannot be done directly cannot be done indirectly. Therefore, when section 397 subsection 2 CRPC prohibits interference in respect of intellectual orders, section 482 CRPC cannot be availed of to achieve the same objective. In other words, since section 397 2 CRPC prohibit interference with intellectual orders, it would not be permissible to resort to section 482 CRPC to set aside an intellectual order. This is what this court held in so-and-so in Amarnath case. Now, para 25, Lordship. This view was reaffirmed in Madhu Limaya case when the following principles were approved in relation to section 482 CRPC in the context of section 397 subsection 2 thereof. The principle, 1, that the power is not to be resorted to if there is a specific provision in the code for the redress of the grievances of the aggrieved party. 2, that it should be exercised very sparingly to prevent abuse of process of any court or otherwise to secure the ends of justice. That it should not be exercised as against the express bar of law engrafted in any other provisions of the code. Therefore, it is quite clear that the prohibition in section 397 CRPC will govern section 482 thereof. We endorse this view. Now kindly come to para 29. This is because, Lordship, they have invoked 482 also. Para 29. This leads us to another facet of the submission made by the learned counsel that even the avenue of proceeding under section 482 CRPC is barred as far as the appellants are concerned. As held in Amarnath, and with which conclusion we agree, if an intellectual order is not revisable due to the prohibition contained in section 397 subsection 2 CRPC, that cannot be circumvented by resort to section 482 CRPC. There can be hardly be any serious disputes on this proposition. So, Lordship, now the settled proposition of law is that, considering the entire factual aspect in this revision petition also, this is not maintainable. And other than that also, Lordship, what they are saying, Lordship, is that in that document which we have exhibited as the exhibit 1, my signature is forged. And what happened? This DW number 12, he himself lodged FIR also before the jurisdictional police station, saying that my signature is forged in that such and such document, the document which himself he exhibited before the trial court. That Lordship will find that paragraph page number 82, last paragraph, married. The learned defense counsel partner submitted that with that regard, that is forgery of his signature, DW12. DW12 has already lodged a complaint before the Palin police station against forgery of his thumb impression in the exhibit number 1 dated 28/4/2018. So now the police will take action in the due course by registering the case, and then that document will be called for by the police and it will be sent to the FSL. So this DW12, he has a remedy. And regarding this document, the exhibit, that is at page, kindly, my brother has not shown that document to your Lordship. That is at page, 79, Lordship. This is the D exhibit 1. This is the mail report addressing to the circle officer. Type copy is at page 80, Lordship. 79 not visible. To the circle officer, Karadari district, Jamin came so and so. Subject report regarding land dispute. Madam, with due respect, we'd like to inform you that land dispute case between Taku and Tunar clan. It is to inform you that with reference to letter number so and so, that the Tunar clan did not attend in the male ground because the Taku clan had damaged the whole garden of Tunar clan. Therefore, madam, please look into the matter and take necessary action, please. And down below, middleman so and so, so and so, so and so, so. Out of this, only one of the arbitrator, he said, I have not put in my signature, and he is DW number 12. So therefore, under the facts and circumstances of the case, Lordship, to my humble understanding to law, this revision is not maintainable. Therefore, this may be dismissed and let the trial court decide on merit. Highly obliged. You have a part heard matter, maybe heard it from 2 p.m.
That's what I'm saying, that we have a part-heard matter, the council is from Guwahati, so let us complete the part-heard matter at 2, and thereafter the other matters will touch. I don't know whether all the matters will be done. These two are pass the order.
No, Your Lordship, I'm also the party. I'll take only 5 minutes in this matter.
Which matter?
The matter that Your Lordship was hearing now.
This one?
Yes, Your
At 2?
Lordship. Yes.
Oh, you are also there?
Yes.
Oh, sorry.
All right. All
The-
right.
इतना देर तक देखिए। सर, हम समझ नहीं आ रहा। 401 और 482 नहीं, प्लीज 97 करेंगे। 401 का वहाँ नहीं
Next week.
Next week, after 2 weeks. That's not good. After 2 weeks.
Okay. May I please, my lord, I beg to mention item number 5. Look, it is an AB. Here the main counsel for the petitioner. Yesterday night he has left to his hometown due to his personal difficulty, my lord. It may be fixed on 29, Monday, my lord.
Otherwise, we have received the case diary here.
Yes, my lord, I have received the case diary, but then I've been informed that his brother is met with an accident. So,
Brother?
yeah, the leading counsel.
Yes.
It may be fixed on Monday, my lord. I've received the case diary, but
Can fix on Monday?
Monday.
May I, Lordship? Lordship, I beg to mention item number 14. Lordship here, yeah, Lordship, in this case, LCR is still not received yet. LCR is not yet received.
No, with LCR, we have received.
And Lordship, moreover, the service upon the respondent is still awaited.
Maybe. Let matter be reached, we'll see. Service upon the respondent is still awaited.
Lordship.
Respond number which?
Sole respondent only,
Sole respondent.
Lordship,
It's not, service is not completed.
not completed, still awaited, Lordship.
You are Mr.
J. Saro.
Huh?
J. Saro.
Okay, husband, so. It is submitted, LCR has already been received. However, it is submitted that is under counsel for this and so. That the service report is still awaited for the sole respondent. After 2 weeks.
Okay, there was an interim. Interim is there, Lordship.
Interim be continued till name is established.
Three.
Interim be continued till name is established.
Deeply obliged.
Lordship, I'd like to mention item number 18. The board, the council are not ready to take any of the matter today.
It was a hearing matter.
Yes.
Who is not ready?
both the party, both councillor not
The
ready.
request made by the council for both sides, matter be adjourned with the direction to proceed with the hearing on the next date without delay. Let the matter be accordingly listed. You want to any date, fixed date,
No, any after 3 weeks, any day.
after 3 weeks?
After
Just,
3 weeks.
after 2 weeks.
After
Just
2
after 2 weeks, with the 2 weeks very list.
Always.
My lord, may I made a mention, item number 17, my lord, it is not appropriate to make a mention, my lord, however, my lord.
It is 14 matter,
My lord,
2014 matter.
my lord.
Ah.
Now, my lord, as per informed by my lord, the PP, he's, my lord, on a medical reason, my lord, he is not available today. My lord, may I pray that matter may be fixed as consented by the other party also, my lord.
PP is not here.
PP is not present today, my lord, owing to a health problem.
Yes,
You
Your
are going to argue this one,
Miss-
item number 17?
Mr. G. Tado was endorsed with this matter, Your Lordship. He is, due to his health condition, Your Lordship is out of station. He'll be available only on Monday.
My lord, as consented by the PP also, my lord, I talked to him over telephone. So, my lord, he'll be available day after tomorrow. So, may I pray the matter may be fixed on 25th, my lord. Day after tomorrow, my lord.
He will be
My lord.
available on Monday.
Or otherwise, my lord, I'm,
Then after 38,
Yes.
30.
my lord, deeply obliged.
You are also there. She is also appearing for whom? For victim?
My senior Shubhukaran.
Convict, my lord.
Acha, for the convict?
Convict, my lord.
Oh, this is against the conviction.
My lord, against the conviction, my lord, but the conviction, my lord, it is beyond, approved beyond reasonable doubt for, my lord, the punishment under 304 second part, my lord. 304, my lord. My lord, conviction is in respect of, my lord, the already set up the, my lord.
This one is for hearing, na, supplementary.
Yes, my lord. Supplementary hearings, item number 17.
They are waiting for this one.
Item number 17.
Item number
You
7,
are on item number 17.
my lord.
So yesterday's matter is item number?
Item number 23, Your Lord.
Yesterday's matter
Yes,
was
yes.
what?
My lord.
I will got confused.
The conviction is, my lord, in respect of, my lord, only the pre-trial, my lord, he has undergone only 45 days. And that has been set off, my lord. So therefore, we are basically coming for the enhancement of the punishment only, my lord. Deeply obliged.
So you may continue until it was item number?
Item number 2, Your Lordship. Now, if I may take Your Lordship to page number 1 of the petition.
Page number?
1, Your Lordship,
Of the petition?
of the petition, Your Lordship. Yeah. Your Lordship will see the application has been filed under section 401, read with
Read with
section
482.
482. Now, if I may take Your Lordship to the prayer, which is at page number 25. Lordship. The first prayer is Deputy Commissioner CEO Radade to produce original document in question to be examined by forensic handwritten expert shall not be set aside. The learned court below shall not be directed to examine the Deputy Commissioner CEO Palin as court witness to clarify that out of 3 orders, which order dated was followed in conducting mail. Now, these are the only 2 grounds, Your Lordship, that has been prayed for. Now, Your Lordship is well aware, though the reference to 482, Your Lordship, I would like to rely upon Madhur Lamia case, which has been relied by both the parties, Your Lordship. I'll be relying paragraph 10, Your Lordship. paragraph 10, if I may read, Your Lordship. As pointed out in Amarnath case, the purpose of putting a bar on the power of revision in relation to any interlocutory order passed in an appeal, inquiry, trial, or other proceeding is to bring about expeditious disposal of the case finally. More often than that, the revisional power of the High Court was resorted to relation to interlocutory order, delaying the final disposal of the proceeding. The legislature, with its wisdom, decided to check this delay by introducing subsection 2 in section 397. On the one hand, a bar has been put in a way of High Court as also of Sessions Judge for exercise of the divisional power in relation to any interlocutory order. On the other hand, the power has been conferred in almost the same term as it was in 1898 Code. On a plain reading of section 482, however, it would follow that nothing in the code which would include subsection 2 of section 397 also shall be deemed to limit for effect the inherent power of the High Court. But if we were to say that the said bar is not to operate in exercise of the inherent power at all, it will be setting at naught one of the limitation imposed upon the exercise of the revisional power. In such a situation, what is the harmonious way out? In our opinion, a happy solution of this problem would be to say that the bar provided in subsection 2 of section 397 operates only in exercise of the revisional power of the High Court, meaning thereby that the High Court will have no power of revision in relation to any interlocutory order. Then, in accordance with one or other principle enunciated about, the inherent power will come into play. There be no other provision in the court for redressal of the grievance of the aggrieved party. But then, if the order assailed is purely of an interlocutory character, which could be corrected in exercise of the revisional power of the High Court under the 1898 Code, the High Court will refuse to exercise its inherent power. Now, the next line is very important, Your Lordship. But in case the impugn order clearly brings about the situation which is an abuse of the process of the court or for the purpose of securing the end of the justice, interference by the High Court is absolutely necessary, then nothing contained in section 397(2) can limit or affect the exercise of the inherent power by the court. But such cases would be few and far between. Now, while relying upon this, Your Lordship will see that the applicant has to prove that there has been a procedure error that under 482, this High Court shall interfere above the limitation imposed under 397(2). Now, taking Your Lordship the point, if there was any error in not considering the IA, Your Lordship. If Your Lordship will come to page number 81, which is the impugn order, Your Lordship. I'll read from the last paragraph, Your Lordship. The instant IA has been filed under section 91 CRPC for directing Circle Officer Palin Kradadi to produce the original document, which is the report dated 28/4/2017, which has been exhibited as Defense Exhibition number 1, signed by 7 arbitrators, middlemen, email between the Tunar and Takan Klein at helipad ground. Learned Defense Counsel has submitted that one of the arbitrator, middle and so, who appeared before the court and was deposed as DW12, stated that he had never put any thumb impression on any report, and further perusal of the record reveals that DW12 deposed before this court that instead he put his signature on documents and not merely put his thumb impression, and that the thumb impression against his name in Defense Exhibit number 1 has been forged by someone for miscarriage of justice. Learned DCA has further submitted that the deposition of the warrants, the intervention of the case, it will be submits that with that regard, DW12 has already lodged a complaint. Your Lordship will see. Learned DC further submits that with that regard, forgery, DW12 has already lodged a complaint before Pali police station against forgery of his thumb impression in the exhibit number 1 dated 28/4/2018. Now, if I may take Your Lordship directly to the page number 83, the last paragraph, Your Lordship. I have heard the respective counsel in detail and also perused the IN number 6 of 2023. The question before this court is whether the prayer of the learned DC for directing the DC Kiradadi to produce the document and to send the same for examination by the forensic handwritten expert is required for proper adjudication of RNGR case number 94 of 2019 and coming to its judicial conclusion. Perusal of the record reveals that the instant trial is plantation of the victim in the instant case. Learned counsel for the victim has rightly pointed out that the issue raised by the learned DC is a completely separate issue than the one in the instant case, and if there are different remedy for DWN as informed by the now your lordship will see that it's a particular case, your lordship. The court cannot go beyond what is to be looked into while dealing with a trial of, and therefore this is maintainable per se, but the applicant has to convince this court that there was any procedural error. As per this impugn order which has been challenged, your lordship, the court has clearly this, your lordship, has come to a conclusion that there was no need of error as such, your lordship, and therefore the impugn order passed by the learned court has been passed in a proper procedure and proper manner, your lordship, taking into consideration all the aspects, your lordship. That's my submission only is limited to this concern, your lordship. Deeply honored.
One is item number 2, no? Heard Mr. Amber, the learned counsel for the petition. We also heard Mr. K. Dama, the learned counsel appearing on behalf of the respondent, and Ms. T. Jimmy, the learned petitioner PP, appearing on behalf of the respondent. And order by fix for order on asking to the party number that will be completed here on the website checks. It will be fixed on 25. 29? 20. The order will be passed on 20. Yes.
Deeply.
Deeply honored.
There are 2 books are there. Paper. Yesterday, what you have been submitted, I have already recorded this thing. Yeah. So don't repeat this.
I will not repeat. I will
Yes.
go forward.
Judgment.
Relying on the grounds already submitted before me, on the report, I will go forward to again in the judgment part. That is in page number. Lordship is page number 156, paper book.
Page number?
Paper book 156.
156.
Yes.
Lordship, the first paragraph, last two lines, and also supported by PW6 812, who in the evening of 15/9/2011 were watching movie in the same hall with the accused. PW6 further stated that accused left the hall half an hour before the end of picture. Lordship, the PW6 statement in cross-examination. Yes, sir.
Lordship, page number 78, Lordship. Page number 78, paper book law. PW6 question.
PW6 78.
Yes, sir.
Lordship, the last part of the cross-examination. When I reached my house after video hall, I found that Kasi Sherpa was already in the sleep in my room. The learned court, trial court below has forgotten this part to mention. And on the basis of that, leaving the watching hall, video hall, he has taken a circumstantial evidence, giving a chain of death. In paragraph number 42 of judgment,
156 page number, again.
Paragraph?
Page number 156, Lordship.
Paragraph 42.
42. The evidences of PW1-2 vividly shows that the accused in meeting conducted on 19/9/2011 stated to have sent the deceased with ₹1,000 and a torch towards Mayo and asked her to wait for him at Lisu camp. Though the accused in his statement recorded under section 313 CRPC denied to have stated the same. I, having seen this corroborative evidence of both the PWs who happen to be a Gaonpura village authority, find no reason to doubt these evidences, and thus, in my considered opinion, these evidences which remained unshaken supports the prosecution case, at least to the extent that both accused and the deceased were together in that night of incident. These are the circumstances evidence taken by for a chain taken by the trial court below. After that, paragraph number 43, last part on next page, and 44. The confessional statement of the accused exhibited at P Exhibit 11 also shows that the accused had remorse for that he did, and as such, I, in the light of authorities referred herein above, have no reason to disbelieve the accused voluntarily confessed his guilt before the learned magistrate. While recording of 164 statement, before that, the accused was in police custody, and that police custody was for 3 periods. First, protection and remand to police custody for 10 days, that is on 3/10/2011. again taken a 4 days transit remand, that is on 13/10/2011. Produced and remanded for 14 days for police custody, produced before JMFC, that is on 17/10. Produced at Mayo and gathered, granted 5 days police custody, that is on 24/10/2011. Where under section 207, produced and sent to judicial custody and where to record 164 statement, that is on 28/10. From 3/10 to 28/10, he is in police custody. 164 statement recorded and sent to judicial custody on 31/10/2011. The trial court record speaks about these dates and orders. After getting bail from trial court, on 9/4/2012, a retraction petition has been filed by the accused. That is on page number. Nine five two retraction 9/5/2012. The page number paper book. Paper page 9/5/2012. Okay. Paper This petition has been filed by the accused after being released on bail. In this petition, he has categorically stated that was arrested by police personnel of Vijayanagar PS on 2/10/2012. 2011.
Lordship, I'm not aware of the application. If that's page number, which page? Page number?
It's a document of the, not in LCR.
LCR, that may be, I may be allowed to see the LCR in that case. Because if the document is not a part of paper book, Your Lordship, I'm not aware of any application of such nature.
Paper book 9 ki.
Because if that
But page number may be recorded. 239 Lordship, from the LCR Lordship. Retracted petition Lordship.
LCR 239.
Yes, Lordship. Page number Lordship.
The first paragraph of our petition is that police personnel of Vijayanagar PS on 2/10/2011.
मैडम को दिखा दो, मैडम को दिखा दो.
And produce him before Judicial Magistrate Second Class Vijayanagar on 3/10/2011. The police have asked for police remand for a period of 10 days, and accordingly the learned JM Second Class Vijayanagar allowed the pair of police remand for the entire period of 10 days. The accused petitioner was produced before the learned court on 13/10 on the basis of the pair.
These are your three, and finally, what you have said, that it was recorded under any compulsion or any, is there any such kind of?
Compulsion कुछ लिखा है इसमें deposit.
Lordship will come to paragraph 5 of the petition.
It's on third page of the petition, paragraph 5. The accused petitioner states that after being released on bail, the accused petitioner could understand the contents of the statements recorded under section 164 CRPC on 31/10/2011, and on today the accused petitioner appear before the honorable court and files this application for retraction of the aforesaid statement under section 164 of Code of Criminal Procedure. This is the retraction petition filed before the trial court. And it has been also mentioned in the judgment by the trial court.
Then the restriction petition, what was the order? It was rejected.
No.
No, no, no. Restriction, was there any order on the restriction petition? No order was passed.
In that retraction petition, we have also mentioned a paragraph. The accused petitioner, on completion of his 14 days of police custody, and surprisingly enough, the police has again prayed for police remand for a period of 14 days. And curiously enough, the London magistrate again allowed the police remand of the accused person for a period of 14 days, despite the fact that the London magistrate is legally not entitled under section 167(2) of the Code of Criminal Procedure to pass any such order of police remand beyond the period of 15 days. It is a classic example of violation of fundamental right of the detainee. This has been clearly mentioned in our petition, but why trial court has not taken in look of on that, I don't know. The 164 statement, which was recorded by the magistrate, page number 32 of paper 2.
Yeah, heredity, judgment.
This confessional statement, 164 statement,
Page number 32, Lordship.
was taken by Magistrate S. Roy, second class. Lordship may kindly peruse the confessional statement. In this statement, no footnote, memorandum, which is to be in complete form, is to be taken.
Also, it's in paper, also in the LCR also, page number, I think, 73 also. LCR also. Page number 73. This.
Lordship, in the 164 statement, the incomplete footnote and memorandum, our first point. The second, no details recorded on police custody. That is our second point. And the treatment got therein by the accused. It has also been not recorded by the. Thereafter, accused signature was not obtained in all the pages. It will be there in the original 164 statement. Questions which were put by magistrate were not voluntary except question number 7. And the 164 statement recorded in a printed form. Besides this, no reference of legal aid to the accused at that time or before the recording of the statement. No specific time was mentioned in 164. No page number in serial. Yes. In this regard, I would like to rely on the judgment of Guwahati High Court. Copy of the same is already available in the record. Because on the last occasion, it was submitted by us. 2008 Criminal Law Journal 1276.
One seven, 1276.
1276. Para 11 and 38. Paragraph 38. May I read, please? The Supreme Court in Kashmira Singh versus State of MP, AIR 1952, SC 159, held as follows. The confession of an accused person is not evidence in the ordinary sense of the term as defined in Section 3. It cannot be made the foundation of a conviction and can only be used in support of other evidence. The proper way is first to marshal the evidence against the accused, excluding the confession altogether from consideration, and see whether, if it is believed, a conviction could safely be based on it. If it is capable of belief independently of the confession, then of course it is necessary to call the confession in aid. But cases may arise where the judge is not prepared to act on the other evidence. As it stands, even enough, if believed, it would be sufficient to sustain a conviction. In such an event, the judge may call in aid the confession. In this case, the confessional statement has been taken as circumstantial evidence. As per
Page number 36.
It's page number 157 LCR Lordship.
Paragraph number 45 of the judgment. And therefore, on cumulative reading of all the evidences as discussed above and confessional statement of the accused recorded by the magistrate, I find the same closely linked up to form complete chain of circumstantial evidence to hold that the accused who in the evening, Baki so and so, and last part of that paragraph is that I finds nothing to hold that accused in any manner intended to cause the death of the accused, death of the disease. And also I find nothing in evidences on record. Here the trial court itself says, and also I find nothing in evidences on record to show that the accused had premeditation to kill their disease.
That's why it is converted to 304 part. That
I am
is the
coming
reason
to that
why
part
it
also.
hasn't been made.
Yes, it does matter.
Confession made by the accused before the magistrate and also his extrajudicial conclusion. Action will be made by the before the case number 148. 27. It will not a decision point for the answer. Left in a chain of evidence. Rely for this. Moreover, one sense should be complete, there should be no gap.
And relying on another judgment passed by Allahabad High Court in regard to confession. I am reading only the footnote part. Confession not recorded according to section 164, inadmissible. Oral evidence of magistrate not admissible to prove it. It also does not amount to extrajudicial confession. This is the footnote. And para 517. Paragraph 17 is the opinion. The aforesaid view has been consistently followed by the Supreme Court in consequent cases. So and so like this. In the present case, the learned ADM did not obtain any written application of the accused surrendering himself in court. In case he had made some admission in that application that might have been admissible in evidence under section 21 of the Evidence Act. So far as the learned magistrate is concerned, he was bound to record the statement under section 164 CRPC only and or not in any other manner. The statements made by the accused before him cannot be treated as extrajudicial confession because at that time he could act as magistrate first class only unknown. This is on page number, paragraph number 17. This is another judgment of 1992, Supreme Court 473. In this, para number 6. The High Court has, on the other hand, made this confessional statement as the basis and has then gone in search of corroboration. It concluded that the confessional statement is corroborated in material particulars by prosecution witnesses, without first considering and marshalling the evidence against the accused, excluding the confession altogether from consideration, as held in this decision cited above, only if on such consideration on the evidence available other than the confession, a conviction can safely be based then. Lordship, in the judgment part, page number 27 of the judgment and
Page number 148, Lord.
148 of paper book. The discussion, decision and reasons thereof, as recorded by trial court. In order to arrive a logical conclusion of the case, I have carefully appreciated, weighted and evaluated entire evidence on records, though there is no direct evidence. Though there is no direct evidence to hold the accused guilty of the alleged charges, the prosecution is relying upon circumstantial evidence coupled with confession made by the accused before magistrate and also his extrajudicial confession made before the village authority. And therefore, in order to seek culpable of the accused, I deem it appropriate to refer some authorities. The paragraph number 32. This is a case of Honorable Apex Court. Herein, Honorable Court has opined in a case based on circumstantial evidence, the settled law is that the circumstances from which the conclusion of guilt is drawn should be fully proved and such circumstances must be conclusive in nature. Moreover, all the circumstances should be completed and there should be no gap left in the chain of evidence. In our case, the person concerned, accused, and the disease and other PWs, some of the PWs were in the video hall. After that, there is no chain. There is no chain how the disease was in place of occurrence. When she goes there, who have seen her, there is no chain after from that period. As because after completion of cinema in video hall, all of them has gone. Accused person has left the cinema hall before half an hour as per PW6. And when PW6 goes to his home, he sees the accused was sleeping as he has to join next day for his duty. So, is there any circumstantial evidence and that too also a chain? Whether the seizures which were seized by the IO completes that chain? No, as because seizures itself speaks. The t-shirt contains this t-shirt and hairs and other undergarments. They are available. And t-shirt is not of accused person. They could not prove it. Prosecution could not prove it. Any part of that seizures list. And prosecution has also failed. Also failed to go for last seen theory. It is almost this is a division bench judgment, Supreme Court of India, versus Anjan Kumar Sharma versus State of Assam. The circumstantial fact is almost same with this case. Thus, herein some small parts are there which Honorable Court, Apex Court has taken. The circumstances from which the conclusion of guilt is to be drawn should be fully established. The circumstances concerned must or should and not may be established. The facts so established should be consistent only with the hypothesis of guilt of the accused. That is to say, they should not be explainable or any other hypothesis except that the accused is guilty. The circumstances should be of conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved. There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. Herein, in our case, almost same of the factual scenario. In our case, the accused has left the video hall, and before leaving the video hall, picture of a 2.5 hours, he met the disease only on that day at video hall, and that too also introduced by her friend, that is PW4. Is there any possibility? Is there any other person, independent person or other independent person from that area? No PWs has been seen, has been taken by the prosecution or by the investigating officer. If that could be a last seen theory, then it could be fatal for the law. As because there are other PWs also there. The brother of the accused, the cousin brother of the accused, and another one aunt of the deceased. His name is Lady Yoben. But the investigating aunt of PW4. Aunt of PW4 and aunt of disease. But she has not been taken as witness. Neither her statement has been recorded by the investigating officer.
Lordship, page number 75, Lordship, PW4. Very important, Lordship.
And it has been said by PW4 in her chief that we have gone to watch video along with our aunt and disease. Why the aunt has not been questioned or why the statement has been recorded, it is a questionable part. As because when disease come with aunt, he may also go with aunt. Is it that he may not have knowledge? Or he may have knowledge? And as such, I find the accused liable to be convicted under section 304. Adjustment case. Here is adjustment to pure 164. Complying counts to mention in our appeal. The accused was over connected in this incident or on the place. And the 164 statement which was affected by the accused and also questionable 164 statement itself is questionable. There was another part which was recorded immediately after police custody. During close custody, he was observed. Even the community, this community, has buried the dead body in his house campus, and the family members are to run from here. Even though police was present, these things happened before the process was. He was not confessed voluntarily, so it's not a part of the judgment.
May I please, Your Lordship?
There was an expectation that it starts with an FIR and the entire scenario of the cases. However, Your Lordship, if I may take Your Lordship to page number 2 of the paper book. This is a case, Your Lordship, where the first instance of complaint was of missing, Your Lordship. On the villagers searching the place of a missing girl, Your Lordship, that's when the murder of the girl was found out, and that's when the case was registered. If Your Lordship will come to page number 2, Your Lordship. They have The same is at page number 31, Your Lordship. Page number 2 does not have there is a typical, they did not type the date, Your Lordship. It's of 21st September 2011, Your Lordship. If I may read, Your Lordship. With due respectfully, I, Shri so-and-so, inhabitants of Gandhi Gram of village, have the honors to state before you that last on dated, Your Lordship may mark the date, 15/9/2011, evening at about 7:45 p.m. RFN, Tashe Sherpa so-and-so, village Dergaon, has adopted my daughter from Bazar Line, Vijayanagar. For the matter, I have complained before the GB Dawoodi for investigation. GB Dawoodi and GB Daragaon has constituted an investigation team on dated 19/9/2011 and done investigation to rifleman so-and-so. Tashi Sherpa said before the committee that he has given a sum of rupees 1,000 only along with his own torchlight and advised her to go down Miao for waiting him in Yobin's camp at Miao. But sir, till date, no any information from Miao whether she has been reached. I have confirmed many more times by PC or telephone, but yet she is not there. I felt that my daughter is missing. Lordship will see that this is not an FIR. This is a missing report. It was addressed to the CO, circle officer, by the father of the victim. Now, if I may take Your Lordship to the FIR, the relevant, Your Lordship will see at page number 4. Your Lordship will come to the serial number 3. GD entry, Your Lordship will see. Entry number so-and-so. Serial number. This is very important, Your Lordship. General Riley reference is entry number so-and-so, time so-and-so. Occurrence is 15/9/2011. Information received is on 21/9/2011. And the GD entry of that information was 44/21/9/2011. Your Lordship will see the complainant at serial number 6. The complaint of missing was made by the father. The complaint was made by the head constable A.K. Mahenta. He is Your Lordship will see in charge Vijayanagar PS. Now, if I may take Your Lordship to page number 5. Serial number 8. Reason for delay in reporting by the complainant informant. Then in charge PS Vijayanagar head constable A.K. Mahenta is not a competent in register a case. However, Changlang PS 011 under section 302 registered by OCPS Changlang basing on IC Vijayanagar of dated 22/9/2011 and case has been regularized on 26/9/2011. Your Lordship will see this was a 0 FIR filed in Changlang. The incident was of Vijayanagar. However, there was no OC. Head constable has filed a 0 FIR in Changlang, and that's when the case was taken up, Your Lordship. Now, if I may read the content of the FIR, Your Lordship. Now, this WT message is the FIR, Your Lordship. Dated 22/9/2011. On 21/9/2011 at 16:40 hours, a written complaint was received from Sri Kifuja Yobin, son of so-and-so, Gandhigram village, PS so-and-so, to the effect that on 15/9/2011 at about 7:45, Rifleman Tashi Sherpa, son of so-and-so, village Deregaon, has eloped his daughter, Miss so-and-so, aged about 14 years, from Bazar Line. He complained before GB Dawoodi village for inquiry into the matter. GB Dawoodi and GB Daragon constituted an investigation team on 19/9/2011 and interrogated to the suspected Tashi Sherpa. During the interrogation, Tashi Sherpa stated that he has given a sum of rupees 1,000 only along with his own torchlight and advised her to go to Miao and awaited him at Yobin's camp at Miao. The complainant contacted his relatives Yobin's camp at Miao over telephone to keep watch her daughter at Miao area, but she has not reached at Miao. The matter is kept in inquiry. On 22/9/2011 at 9 hours, villagers of Dawoodi and Deregaon along with GBs of the said village and public leaders started searching Miss Yathini Yobin at village area, Jungle River and Paddy Field and found the dead body of late so-and-so at Cliff Ditch roadside at Deregaon at 10:30 hours. Visited inquest conducted over the dead body of the deceased and photographs taken. The post-mortem could not be conducted due to non-availability of MO at the PHC. Request detail OC police officer for further necessary investigation of the case for information and necessary instruction. Now, it was only by the villagers, both the head government, the villagers who had made an investigation, Your Lordship, and their power is in the AFR. They can help the police in during the entire investigation, Your Lordship. Now, when the dead body was found, Your Lordship will come to page number 1. The circle officer who at that point of time is a magistrate, first class magistrate, Your Lordship. For thorough investigation, the dead body of so-and-so of the gun. You are hereby directed to proceed to the spot where the dead body lying of so-and-so for thorough investigation and other necessary action to be taken up in regard to the that occurred. Now, Your Lordship will see that how can a police station in a place does not have a officer in charge, Your Lordship. If I may take Your Lordship to page number 41, which is the charge sheet, Your Lordship. The entire villages and the entire administration, how did they tackle the shortage of manpower at that point of time, Your Lordship? Because Vijayanagar is such a place which has recently, in the year 2023, got a Kacha road to their village, Your Lordship. And therefore, in the year 2011, when even the judiciary and executive was not separated in the state, Your Lordship, this was the condition. This, and I'm reading this because the information about the recovery of the dead body of the victim girl, late so-and-so, H.C. A.K. Mehta, the then IC, Your Lordship will see in charge, ICOC PS VNR, visited the PO and took photographs of the PO and the deceased. The dead body of the late so-and-so was found concealed with mud and stone with left lower limb exposed. With the help of the villagers, the dead body was recovered and dug out from the ditch. The dead body was mostly decomposed with its head detached from the body. Inquest conducted over the corpse, but no injury mark or identification mark could apparently be seen due to signal number, and all of these documents I have verified, Your Lordship, is in the CDA case record. VNR so-and-so dated 22/9/2011, the SP Changlang directed OCPS Changlang to register a regular case wide 0 FIR under section 302 at Changlang PS on the condition that the case could be transferred to VNR PS on joining of regular OC. Accordingly, on 23/9/2011, OCPS Changlang Inspector T. Tanga registered a 0 FIR under section 302 with a view to hand over the case to OCPS Vijayanagar on his joining. On the night of 25/09/2011, I was verbally directed by SP Changlang, Sri Tumme Amo, to proceed to VNR for investigation purpose. On 26/9/2011, I availed the helicopter from Mohanbari, wherein Honorable Home Minister so-and-so, DC Changlang, SP Changlang, CO and MO PH so-and-so were on the board. On arrival at VNR PS, I took over the PS charge from HC A.K. Mehta and regularized the Changlang PS case under so-and-so, white, treating the original WT message of dated as FIR. Now, Your Lordship will see neither there was MO, nor SP, nor a regular OC. Everyone has to be flown from Changlang to deal with the investigation of this case. Now, with regard to the 201. However, after the evidences where he was convicted under 3042. Now, if your lordship will come to the medical report, which is at page number. Prior to that, your lordship will come to page number 17. This is the medical examination report of the accused, your lordship. Hmm, 17. I'll read only the external finding of the body, your lordship. There are 4 numbers of round vertical arranged scar marks on the right side of the face, each scar face measuring 3 millimeter in size and half centimeter apart. 2 numbers of scar marks measuring 2 centimeter in length on the right anterior cubical region. 1 linear scar mark seen on forehead, forearms, extending from the middle of the forearm and laterally extending down towards and reach lateral and at the right wrist. 2 numbers of scar mark measuring 1 centimeter parallel to each other on the left dorsal surface of the hand. 1 horizontal all scar mark measuring 2 centimeter in breadth and around 15 centimeter in length present on the just about right knee. Tattoo marks present on both the sides. The exact nature and so and its age cannot be ascertained. Skin specialist can be consulted. If I may read, your lordship. Due to extreme decomposition of the body, exact nature cut injury cannot be differentiated. Also, due to extreme decomposition, the neck and head portion is totally skeletonical. No any sign of flesh left. With cervical vertebra attached to the vocal vertebrae, left temporal bone, fragment of bone missing measuring so and so. There is also fracture of so and so. Now, if your lordship will come to opinion of the sub-assistant surgeon, your lordship. In my opinion, the case of death is due to cervical fracture and a fracture of the skull on the temporal bone and occipital bone, lending to massive hemorrhage and cause the death. The exact nature of the death cannot be ascertained due to extreme decomposition, but as head is separated from the neck and circumstantial evidence on the side of the recovery shows that it is likely to be homicide in nature. And therefore, 3042, your lordship. Your lordship will see that the purpose for reading the entire document was that any injury could not be found because the dead body was found after, as already has been submitted, your lordship. It was during lordship. PW1 is a very important witness. If your lordship will come to page number 67. Yes. He is the Gambura of the Dawadi village, your lordship. If I may read, your lordship. I know the accused standing on the dock. If I may read only the relevant paragraph, your lordship. If I may take your lordship to 11th line, your lordship. It starts with, we narrated the missing girl to Terengaon GBs.
11 line.
Yes. The middle part the sentence starts with, we narrated the missing We narrated the missing of the girl to Teregaon GB. The GB then told us that the accused Tashi Sherpa has already joined his duty. On the same day, they went to Assam Rifle to inquire about the matter. However, I did not go there. I came back home. On that day, they did not give any report. But in the evening, GB of Teregaon informed us that on next day, on 18/9/2011, accused Sherpa will be given outpass to come from the camp for inquiry. We have formed committee consists of 9 members to inquire accused Tashi Sherpa about the missing of the girl. On 18/9/2011, Tashi Sherpa was not given outpass. We waited for him the whole day. On repeated requests made to the Assam Rifle Authority, in the evening we received an information that accused Tashi Sherpa was already given outpass on the same day and he went out from the gate number 2, but on that day the accused did not report to the committee. Thereafter we searched for the accused. Ultimately his brother Dawa found the accused inside AR camp. Knowing this, Kul Bahadur again went inside camp and sought permission from in-charge captain and requested him to permit the accused, Tashi Sherpa, to go out to meet his sick mother who had become very weak. On 19/11/2009, accused was permitted to go out. We inquired him about the missing of the girl in the house of Lamte Lucy at Bazar Line. During the whole day inquiry, the accused did not disclose anything. But in the last moment, he admitted he has given a torchlight and 1,000 rupees to the girl so-and-so and asked her to go to Miao and waited for him at Lisu camp. After the inquiry, the accused was sent back to the camp. Now this GB, Your Lordship, any confession with regard to being with the girl at the last moment was also made to this GB, PW. He is also a witness to this extrajudicial confession, Your Lordship. Now the cross, Your Lordship, will see. I am the 8th GB of the Dawadi village and 2nd GB is Sariko at page number 16. When some serious case happen in the village, the 8th GB will inform the 2nd GB and other members also. Any other pretty case can be tackled by 8th GB alone also. As the 2nd GB was at Gandhigram, which is 19 kilometers away from my village, I did not inform the matter to him. It is not a fact that I intentionally did not inform the 2nd GB. In the inquiry committee, which was formed on 17/9/2011, there were 9 members. The committee was formed after conducting meeting. Police has recorded my stem. Now, Your Lordship will see he has clearly stated that if there is any proviso, any such kind of incident that happens in the village authority can take up the cases, Your Lordship. And as such, he had taken up the case. They have conducted a meeting. They, in a very proper manner, they had approached the Assam Rifle Authority to let him, give him a pass to let him out. He was seated in the committee. He was asked about what happened because the village authority was inquiring about the missing of the girl. Till this time, Your Lordship will see, they were not aware that the girl was already dead. Now, if I may take Your Lordship to PW 270, Your Lordship. He is the father of the victim. Though I won't read the entire this, Your Lordship. However, as per his statement, it was informed to him by the aunt of the victim that she did not come back, Your Lordship. And then she had complained before the GB, Your Lordship. Now, during the entire process of when the accused was called and he had made a confession that he was last seen with her, the father of the victim was not in that meeting. And the fact, he's just a hearsay of the say. The fact that the 1,000 rupees was given was told to him by the other GBs, Your Lordship. Now PW3, Your Lordship. I'll read only the relevant part, Your Lordship. My Lord may just record that he is the GB of Deregaon. He is the GB of the village from where the accused belong, Your Lordship. If Your Lordship will come to page number 73. Fifteenth line, Your Lordship will see. 15th line, your lordship will see. Your lordship will see, since he was also present in the meeting, if I may read. At last, the accused, finding this clause, said that he gave so and so rupees to the and torch to the victim girl, asked her to go and wait at Lisu camp. From there, he'll take her along with him in aeroplane. Then 10 minutes before the allotment time for interrogation, all the members of the committee took the. Now he is also a person before whom the accused has made a confession that he was last seen with the victim, your lordship. Now this is the GB who had informed at page number 74, your lordship will see. The 8th line, your lordship will see. He has clearly stated that the father of the victim was not present in the inquiry meeting. Now, PW4 is a very important witness, your lordship. And I would like to read the entire statement, your lordship. I know the person standing on the dock. She is the one who was along with the victim while watching the movie, your lordship. I know the person standing on the dock, his name is so-and-so. On 15/9/2011, in the evening time, along with two other lady, Yetini and Lidi Yobin, went for cinema at Vijayanagar. We are sitting in the cinema hall. The accused, Tasi Sherpa, was talking my friend Yetini from backside and was asking her to come out in the outside for 5 minutes to talk her. Then my friend Yetini went along with accused from cinema hall to outside, but both of them had come back to cinema hall. After watching the cinema, we went back to our house without my friend. That may be recorded, your lordship. The entire during the entire watching of the cinema, she has seen both of them talking. They have gone outside also. They have come back as per her statement. However, by leaving from the cinema hall, she did not leave it. The victim did not leave along with them, your lordship. Now, if I may take your lordship to page number 76, which is the cross of the defense, your lordship. It is true, the so-and-so, my signature in the exhibit was put in the police station at Vijayanagar. The video hall is not very large to me. Hall will accommodate 30 people approximately. The door of the video hall is in the back side of the sitting chair. I, along with my friend, were sitting in the second line of the front side. When we entered in the hall, the accused was already sitting in that hall and he was sitting on the third line from the front, just next to our line. Accused was introducing himself to be my deceased friend, as his name is Tashi Sherpa. Your lordship will see, accused was introducing himself to my deceased friend as his name is Tashi Sherpa and he was working in army. He came on leave. It is not a fact that I have stated before the IA that after 10 minutes in the hall, one Tashi Sherpa, whom I know as RFM, came closer to us and talked to us. And it is also not a fact that I have stated before the IO that I have insisted them to go out of the hall if they want to talk, as I'm feeling undisturbed. It is also not a fact that I have stated before the IO that my deceased friend had gone out of the hall by saying that she is gone outside for urine. Your lordship may take note of the next line. My deceased friend went out first from the hall and she was followed by the accused person instantly. There was never a question put up if they then came back together, your lordship. I cannot say how many other people had gone out from the cinema when the picture was running. Now the next is PW5. I'll skip PW5 because she's a hearsay witness. She's the mother of the victim, your lordship. PW6, your lordship will see, he's also a friend of the accused. If I may read from the 4th line, 5th line, your lordship. My house and the house of the accused is near to each other's village. The accused was also on leave at that time. He was posted at Nagaland at that time. On day of incident, I, along with Samir Chhetri, went for video. On the way, we met accused Tashi Sherpa, who also came with us for video. Accordingly, 3 of us went to the video hall and seen the video together. But before the end of the picture, Tashi Sherpa left the video hall. Lordship will see, every one of them has stated that he went to a video hall and before the movie was over, he had left in the midway, lordship. Now, if I may take his statement, which they have relied, lordship will see at page number 79, the last line. When I reached home after video hall, I found that Tashi was already in the sleep in my room. Your Lordship will see in my room. Next is the father of the accused, Your Lordship. Your Lordship, if I may take 1, 2, 3, 4, 5. The 13th line, it starts on 15th evening. On 15th evening, I don't know where they were, but on the day of 16th, they went to jungle for collecting of some timber posts. By evening, son had left to the duty. He had left on the 16th, Your Lordship. 15th, he was very much in the town, Your Lordship. There is no reference as to if his son was sleeping in any other friend's house or not. Now, if I may take Your Lordship to PW8, who had also seen the accused in the cinema hall and leaving midway. The second last line, Your Lordship will see. However, after some time, accused went from that bench to front line of the bench. PW9, Your Lordship, is the elder brother. There is no statement with regard to this particular case, except for the fact that his brother had come for a marriage ceremony and had left on the other day. Next is PW10, Your Lordship. She is the elder sister of the victim. If I may read from the 5th line, Your Lordship. On the morning of 6th November. On the morning of 6th November 2011 at 8 a.m., Sif Avinash Yobin came. Avinash Yobin is, Your Lordship will see, the PW4 who was with the victim, to me and was asking me whether my late sister came back to house or not. As they went for picture last evening, but middle of the show, she went out with the accused person, Your Lordship will see, and did not come back to home. I waited for whole day by thinking that she will return, as she did not return. Therefore, I went out to search her nearby the areas and village, but did not found her. Later in the evening, I informed the Gaombura of Dawadi village about missing of my younger sister. On next day, I made telephone call to my parents and told them about the missing of my sister. Then on 18th November 2011, my parents came from village to Vijayanagar. And on 19th, the committee was formed and search was made, Your Lordship. She is also a hearsay witness, Your Lordship. PW11, Your Lordship. She is also was in the search team, Your Lordship. Not necessary. PW12 is also the person who has seen the accused in the cinema hall. If I may read the second last line, Your Lordship. In the middle of the show, accused went out from the video hall by showing his hand in gesture that he is leaving the hall to us. I did not give any attention whether any person went out the hall before or after Tashi Sherpa from the video hall or not. PW13 is the MO. 5 is the witness of the police station when the WT message, which was later converted into FIR, she has witnessed the exhibit of WT message a lot. PW16. PW16 is the head constable, one of the very important witness, your lordship. If I may read, your lordship, his statement, not entire statement, but because as per their submission, they have also made in absence of OC. I don't remember exact date, probably on 21 of that month, the father of the deceased lodged a written FIR in our police officers T. Singh 4, Circle Inspector of the area. Then she directed me to make a GD entry. And therefore, my reference was that this matter was first entered into Vijayanagar with the information that the dead body of the deceased was recovered, and we were requested to do down. The dead body was found in a deep gorge, which will be about 120 feet down, and the road of the Biao Narayan Thapa. Next page, your lordship. Exhibit 13B is my signature on the same document. Madam T. Singh 4 already expired a month back. I'm complaint. It is true the GD entry made on that is not in the case record of the court. It is not the fact that I have not made a GD entry on the direction of the officer. It is not true. There is no written record that I was directed to make inquiry about the complaint from the senior officer. I don't remember if I have prepared any case diary or supplementary in the case. It is true. There is no written record in the case record directing me to prepare the inquest on the dead body. It is true. I have not recorded myself to the fact that when I reached to the spot on getting information on recovery of the dead body was almost dumped and buried. Only her one leg could be seen. But I have stated before the IO of the case of the same fact. It is not a fact that I have not stated so and so. If I may take your lordship to the fourth last line. It is true, I prepared that the PO on the of such direct case may prepared. Dead body was found is not indicated. It is true the distance of recovery of material from the PO indicated in P is not mentioned, nor the location of so and so. Further, your lordship, a question was put. You don't know how to prepare the sketch map of PO wrongly? Maybe. I don't know on which date Madam Singpo has become the IO of this case. I don't remember when the accused was arrested, how many days he was in the custody in remand, and from where he was remanded. I don't know whether Madam had taken the statement of the witness. Since he was not the investigation authority, your lordship, he is not aware of those. Your lordship will see he has clearly stated even there was anomalies during the investigation, your lordship. Now, PW 17, which is the magistrate, your lordship. I have also checked the entire record, LCR record, your lordship. With regard to the question of if he was in police custody or in judicial custody when his statement was recorded under 164, has also been clearly in page number 6 of the LCR. The order sheets are available, your lordship. Now, if I may read. I identified the person standing on the dock. He is so-and-so. Accused was produced before me for the first time on 31/10/2011. In the case, I have recorded the confessional statement of the accused on 31/10/2011. I have put 8 questions to the accused, which is on record. Accused confessed before me that in the evening, so-and-so, 59, he met the deceased inside the video hall at Vijayanagar. Within few hours, they attracted each other and went out of the video hall. They seated for some time in the road near the SB camp. Thereafter went to the nearby jungle and had sex. Thereafter, accused asked the deceased to go back to her house, but deceased insisted the accused to take her. On this, the accused pushed her back once, but deceased again came back and adamant to go with the accused. Accused for the second time pushed the deceased, on which deceased fall down in the deep gorge. Accused also went down to that place where he found the dead body of the deceased. Accused, after finding that the deceased had died, he put some boulder over her body. He came up and wanted to disclose the incident, but he could not do so due to fear next day. He joined his duty. Accused also stated before me that the incident took place unintentionally. Accused also disclosed the name of one Miss Abinas Yobin. Your lordship will see they have met because he had clearly confessed that she knows this Miss who is the PW4, your lordship. To one of the person who were present inside the video hall in that evening. Accused was produced before me from the judicial custody. Now, the sequence of when he was presented, crossed by the defense. I was working as magistrate at Miao from the year 2004 to September 2013. It is not the fact that accused was produced before me earlier than 31/10/2011. I forgot the first day of production of the accused because it had already 2-3 years. After going through the record, I found that the accused was produced before me for the first time on 24/10/2011. I don't remember whether accused were 26 days in the custody before the recording of the statement. I have recorded the confessional statement on the requisition of IO, which received on 28/10/2011. 28/10/2011 is the day when the requisition was made, your lordship. The DP Exhibit 1 is the letter dated 28/10/2011 received from the IO for the same. The order dated 28/10/2011 will be in the case record. It is true the police custody and judicial custody of Miao are in separate building but adjacent to each other. It is a fact that treatment meted to the accused was not put to the accused before recording. Without permission of the accused, court accused cannot be met by relatives. I don't remember application. Your Lordship will see, I don't remember any application if I have received from the relative to meet the accused. It is not to suggest that I have not reflected in my order sheet dated 28/10/2011 that the accused be produced on 31/10/2011 and time given in between for reflection. Whatever I have stated today is true. Now he has made, it's even, I have rechecked it, Your Lordship, it's even in the court record that he was first produced on 24, an application was made on 28 for recording of 164 statement, and a reflection time till next day, that is 31/10, he was to be produced for giving his statement, Your Lordship. Next is PW 17 is the IO. His statement was just with regard to recognizing the signature of IO who had expired after the charge sheet was filed. Now, if I may take Your Lordship to 164, 32, Your Lordship, page number 32. Meow, Your Lordship will see 31 October 2000. It's 11, which has been wrongly written as 12, Your Lordship. Your Lordship will see in serial number 3, having talked with accused, explaining to him each of the matter mentioned in paragraph 3 hereunder and cautioned his that he or she ought to reflect carefully before making any statement. I have placed him or her in charge of Sri R.B. Pradhan, who is the peon of, and directed the accused to wait in the waiting room of ADC's office, Meow, in order that he or she may have time to reflect before making statement. I have satisfied myself that there is no police officer in the court in any place where the proceeding can be seen and except the above. The Now, if I may take Your Lordship to page number 33, the question put, Your Lordship. What is it? Question number 35, 5, Your Lordship, 34, page number 34. Question number 6, Your Lordship. Do you know why you have been arrested? I have been arrested in murder of Miss So-and-so, Gandhigram village. Do you want to give your statements? Yes, I want to give voluntarily. After knowing consequences, statement voluntarily, and whatever speak will be true, Your Lordship. If I may read the statement, Your Lordship. On 15/9/2011 at about 18:30 hours, I went to video hall in Vijayanagar. After entering inside, I saw the girl sitting in front of my seat. I started talking to her and asking her name. She replied her name is Acha Yobin and she hails from Gandhigram. I further inquired about her qualification. She replied that she studied in class 9. After that, I proposed her whether she loved me. I informed her that I have already fallen in love with her. She first discussed with her friend Abhinas Yobin and then replied with affirmation. At about 2000 hours, I along with late Acha Yobin came out of the video hall and asked towards SB camp and rested in the weighted shed where SB camp. After sometimes we went far up to 30 feet towards Deragaon. Your Lordship will see Deragaon village where the incident has happened and has sex in the jungle. Thereafter, I asked late Acha to leave for her sister, but she refused to answer and forced me to marry her on spot. But I requested her to wait for the time being till my next visit to Vijayanagar or on leave, as I had to join my service on the very next day. She refused to accept my advice, rather insisted me to take her to my house then and there. I requested her time and again not to be adamant and let me take her to her sister's house, but she denied and sat there firmly. Then I lost my control and told her to go to anywhere, and I was leaving for my home. She then stood up and ran towards me and caught hold of my arm and forced me to take her to my home. Having no other option, I pushed her back, then she fell down on the ground. I again started to leave for my house alone. She again ran towards me and caught hold of my arm. I then again pushed her with force, and unfortunately she fell down the gorge about 100 feet deep. I heard the sound of her falling down. I then immediately ran down the gorge and saw that her body was lying on the ground with pool of blood. I was so nervous that at that moment that out of fear, I covered her body with stone and mud and ran with intention to tell somebody, if available, up the road. but I could not find anybody. After some time, I thought that nobody could believe that the incident happened accidentally, and of fear, I decided to conceal the fact and rush to my home. I could not sleep at that night. Your Lordship, the small point that I decided to conceal the fact and rushed to my home, which is in contradictory to what one of his cousin, elder brother, that he was sleeping in my home. I could not sleep at night that night. Next morning, I joined my duty on Vijayanagar AR camp. I could not divulge the fact to anybody out of fear, but I was thinking of narrate the true fact, maybe a time, but got tense and nervous. On 22/9/2011, the village searched out the dead body, and immediately hearing the news, the Assam Rifle Authority took me to their custody. It should be, the date should be 10/2011, I was held over to the civil police and detained in the police lockup at Vijayanagar. Your Lordship will see he has also admitted to the fact that he was locked up in the Vijayanagar till 28/10/2011. On 28/10/2011, I have been detained in judicial custody and still kept there. I was not intended to murder her, but what happened was an incident, and I feel sorry for the incident. Now, Your Lordship is well aware. Your Lordship is now well aware that if there is any retraction with regard to the confessional statement, can the entire confession statement be thrown overboard? No. Now, if Your Lordship will come to page number 112, Your Lordship. This is the 313 statement of the accused, Your Lordship. He has denied to some and had not made any given any reason for the other question, Your Lordship. If I may take Your Lordship to page number 116, question number 25. Lordship will see the question number 25, that PW6 so and so stated that in the month of 2011, one evening, he along with you and one Samir Chetri went for video, but before the end of the picture, you went up the hall. Yes, this is true. I left the hall as I was to join my duty. So he has admitted to the fact that they have gone for the duty. He was in the video hall on the same day and he had left midway. Now, if I may take Your Lordship to page number 118, Your Lordship. That question number 39, Your Lordship. That PW13 further state that he on your examination found 4 scar marks on your right face, 2 scar marks on your right hand, 1 scar marks on your knee, 2 scar marks on your left hand. Do you have anything to say on this? His answer is, this is not true. Though I have scar on my face, it is of my pimples. Your Lordship will see the scar only of his face. He has made an answer, but the rest of it, he has not given any justification to the scar marks, Your Lordship. Your Lordship will see at page question number 41. That PW13 further stated to have heard you telling the police that you sent the, Your Lordship will see, PW13 further stated to have heard you telling the police that you sent the deceased girl to Mia with torch and rupees 1,000 and assured to come back to the same to meeting. Do you have anything to say? His answer is, yes, I have stated that due to pressure and torture exerted upon me by the police. Now, Your Lordship will see PW13 is the MO. Rest of the, he has only stated that he in this retraction 313, he has stated that this was out of the pressure of and torture of the police, Your Lordship. Now, at page number 121, Your Lordship, Question number 51. That the PW 17 Shri so and so stated to have recorded your confessional statement on so and so, wherein you have stated to have pushed down deceased to deep jail. What do you have to say? It is true that my statement was recorded by the magistrate. I had admitted to the guilt due to the torture. He has admitted to the fact that he has given a statement under 164 voluntarily as such, but under the his retracted statement is that he has given it due to the torture of the police. Now, if I may take your lordship to the AFR, your lordship. And the reason for relying on AFR is to the involvement of Gaon Buras in a village when such incident happens, your lordship. If your lordship will come to page number 55. Section 6, your lordship will see. The ordinary duties of police in respect of crime shall be discharged by the village authority. They shall maintain peace and order within their jurisdiction. The village authority shall not be deemed to be police officer forsooth. Third, the village authorities shall watch and report on any vagrant or any bad or suspicious character found within their jurisdiction and may apprehend any person, such person, if they have reasonable ground for suspecting that he has committed or is about to commit an offense, and shall hand over any person to so apprehend to the Deputy Commissioner or Assistant Commissioner. 8, your lordship will see, on commission of any heinous offense within their jurisdiction, the inhabitants of the village shall at once, if possible, apprehend the offender, and in any case shall at once inform the village authority, who, if the offender has not been apprehended, shall proceed without delay to the place where the offense was committed and inquire into it. Now, my reliance on this is that first, a complaint was given on when they found that the girl was missing, your lordship. The first complaint was of the missing to the circle officer. That complaint was, after the complaint, a search committee was made. It was revealed that the accused was last seen with the victim, your lordship. And upon knowing that, there was permission sought from the higher authority of the accused, and he was brought during that meeting. And there he made an extrajudicial confession that he has admitted to the fact that he was the last person to be with the accused. After he has given so and so rupees and torch and asked the girl to wait for him to meow, your lordship, thereafter the chain breaks, your lordship. The fact, subsequently, when this entire head constable he knows that he could not have registered this case, he made a GD entry, which is clearly reflected in the FIR, your lordship. He made a GD entry, and that GD entry later, when it was reported to the SP Changlang, a 0 FIR was filed in Changlang, and after the authorities and administration has come to the Vijayanagar, that's when the FIR was made absolute and registered, your lordship. Now, if your lordship will see that after the breaking of the chain, that he has, even their submission was that there is no seizure of torch or any of the rupees whatsoever he was given, your lordship, because that was a confession made, that was extrajudicial confession being made to the Gaon Buras. However, in 164 of the confession, he has the missing chain, that after the video hall, what did they do, where the incident happened. And your lordship will also see that when the dead body was found, it was covered by mud and stone as described by him, your lordship. And then subsequently on the next day, he had come back home. On the next day, he had joined. There are, all the prosecution witness has clearly stated that he was in the video hall. He had left in the midway. The prime witness, that is PW4, has clearly stated that her friend, victim friend, and he was talking and they had gone outside together. Now, this chain was completed by him through his 164 statement. Now, if I may take your lordship, I would rely upon this State of Tamil Nadu versus Kutti alias Lakshmi Narasimha, this is a judicial confession, Your Lordship. Paragraph 13 and 14. How much of a retracted confession, how much of a confession and how much of a retracted confession has to be taken into consideration, Your Lordship? Paragraph 13 and 14. It is not true that the law that once a confession was retracted, the court shall presume that the confession is tainted. As a matter of practical knowledge, we can say that non-retracted confession is a rarity in criminal case. To retract from confession is the right of the confessor, and all the accused against whom confessions were produced by the prosecution have invariably adopted that right. It would be injudicious to jettison a judicial confession on the mere premise that its maker has retracted from it. The court has a duty to evaluate the evidence concerning the confession by looking at all aspects. The twin test of a confession is to ascertain whether it was voluntarily and true. Once these tests are found to be positive, the next endeavor is to see whether there is any other reason which stand in the way of acting in it. Even for the retraction of the confession is not ground to throw the confession overboard. We are unable to understand how a judicial confession would become bad by reason of the fact that articles belong to the victims were recovered prior to making of the confession. That aspect, instead of vitiating the confession, could be a factor in favor of the voluntariness of the confession. When the culprit finds that the article concealed by him are all disinterred, it is possible that he may feel that there is no use in concealing the fact anymore. Then he may desire to make a clean breast of everything to any person or authorities. Now, even with regard to this, Your Lordship, the application that they were relying upon just a second before, Your Lordship, there is no record if the application has been numbered, if the application was filed, if the application was taken into consideration by the court, Your Lordship. There is no such order as such. Now, Your Lordship will also see, this application is filed, dated is 9/4/2012, Your Lordship. Even in the entire application, there is no, this is from the court's record, right? This is from the court's record, but 239 is? Court.
You can see it from here.
Yes, Your Lordship. You also will see that this application, if any order was passed, the application has not been numbered, Your Lordship. No, there is no number. No, this I application does not have any number. Yes, there is no seal of the court. Neither the stamp has been sealed in any manner. However, Your Lordship, at that point of time, when this retraction, prayer for retraction was not considered, Your Lordship will not consider the same during this during this appeal to Your Lordship, because the same was also not put before the final argument in the main case. Now, if I may take Your Lordship to another judgment on how much of a reflection time should a accused be given prior to his recording of statement under 164. If Your Lordship will come to page, paragraph 40. 40, Your Lordship. Down below the page number is written, Your Lordship, it's page 10. Although the interval between the preliminary question of the appellant and this confession was about 15 minutes, the appellant had no less than 38 hours at his disposal, whilst he was in judicial custody, free from fear or influence of the police, to think and decide whether or not to make a confession. As noticed already, the appellant was brought from Gandhigram, so on June 12, 1974, because on that day no magistrate competent to record the confession of so-and-so was available at Gandhigram. The appellant was admitted to the judicial lockup under the order of magistrate or after 4 p.m. on that day. Thereafter, the appellant continuously remained in the judicial lockup or judicial custody till his confession was recorded on June 1974, 8:45 a.m., Your Lordship, onwards. The magistrate C so-and-so was aware that the appellant was continuously in judicial custody since the evening. Now, paragraph 42, Your Lordship. It will be seen that how much time for reflection should be allowed to an accused before recording his confession is a question which depends on the circumstances of each case. The object of giving such time for reflection to the accused is to ensure that he is completely free from police influence. If immediately before the recording of the confession, the accused was in the judicial custody beyond the reach of the investigation police for some days, then such custody from its very true nature may itself be a factor dispelling fear or influence of the police from the mind of the accused. In such case, it may not be necessary to send back the accused person for any prolonged period to jail or judicial lockup. In the instant case, the accused was not accused got admitted to the judicial lockup on 12 June for getting his confession recorded under 164 CRPC, and such admission was made under the order of the magistrate who ultimately recorded his confession on 14th. The accused was about 2 days in judicial custody beyond the reach of the police. On June 30, 1974, a written request was made by the magistrate by the police for recording the confession of the accused. Even then, the magistrate postponed the recording of the confession till the following day, obviously because he wanted to give the appellant 1 day more in judicial custody to ponder over the matter free from police influence. On 14 June, notwithstanding the fact that the accused so-and-so was in judicial custody from the evening of 12th June after the preliminary question, the magistrate allowed 15 minutes more to him for reflection. This thus considered so-and-so had, as a matter of fact, about 38 or 40 hours in judicial custody immediately preceding the confession, and this was rightly considered sufficient to secure the freedom from fear or influence of the police to him. Now, even in this case, Your Lordship will see 2 days was given. 28, if I may, yes, Your Lordship has seen. He was for confessional statement on 28. He was sent back on his statement was taken on 30th, Your Lordship. He was given a proper time for reflection, Your Lordship. Now, with regard to defect in investigation, Your Lordship will see. Your Lordship I have read the entire statement of the IO because the head constable, because he has admitted to the fact that there were anomalies during investigation. Some of the authorities he were not given, but at that circumstances, Your Lordship, he had to do, otherwise it would be a failure on his part, Your Lordship. Now, if I may take Your Lordship to paragraph 42, that is the last page, Your Lordship. Last page, Your Lordship. Although mere defect in the investigation process by itself cannot constitute ground for acquittal, it is the legal obligation of the court to examine carefully in each case the prosecution evidence, the lapses committed by the investigation officer to find out whether the evidence brought on record is at all reliable and whether such lapses affect the object of finding out the truth. Being conscious of the above position in law and to avoid erosion of the faith and confidence of the people in the administrative of criminal justice, this court has examined the evidence led by the prosecution threadbare and refrained from giving primacy to the negligence of the investigation officer as well as to the omission or lapse resulting from perfunctory investigation undertaken by him. The endeavor of this court has been to reach the root of the matter by analyzing and assessing the evidence on record and to ascertain whether the appellant were duly found to be guilty as well as to ensure that the guilty does not escape the rigors of law. The disturbing feature in the process of investigation since notice have not weighed in the court's mind to give the benefit of doubt to the appellant, but on proper evaluation of various facts and circumstances, it has transpired that there were reasons for which PW might have falsely implicated so and so. Now, even in this case, Your Lordship will see that for the lapses of any investigation or any omission, Your Lordship, the court has to see the facts and circumstances on which such lapses and omission has been made, Your Lordship. Another is with regard to 313, Your Lordship. I'll just place only the relevant parts, Your Lordship. This being important, Your Lordship will see why I was pointing at the question with regard to the scar marks and the importance of 313. If Your Lordship will come to page number 6, paragraph 12. Paragraph 12, Your Lordship. Page number 6. Paragraph 12, Your Lordship. The accused has a duty to furnish an explanation in his statement under section 313 CRPC regarding any incriminating material that has been produced against him. If the accused has been given the freedom to remain silent during the investigation as well before the court, then the accused may choose to maintain silence or even remain in complete denial when his statement under section 313 CRPC is being recorded. However, in such an event, the court will be entitled to draw an interference, including such adverse inference against the accused as may be permissible in accordance with law. Next, in the instant case, as the appellant did not take any defense or furnish any explanation as to any of the incriminating material placed by the trial court, the court below have rightly drawn an adverse inference against him. The appellant has not denied his presence in the house on that night. When the accused were left in the custody of the appellant, he was want to explain as to what circumstances. Now, Your Lordship will see just a denial won't be suffice in 313. There has to be an explanation, Your Lordship. Now, with regard to the explanation as to his scar mark, Your Lordship will see he has given only of the space but not of the rest of the scar marks. The citation is of extrajudicial confession, Your Lordship. This is of our own High Court, and the reason I'm relying this is of a very small to a very small part, Your Lordship. I'll be relying on paragraph 23, that is at page number 6, Your Lordship. Paragraph 23 and 24, Your Lordship. I'll just rely, Your Lordship. Your Lordship is well aware of this. In this matter, if I may take only to the part paragraph 36, Your Lordship. 23 and 24 is with regard to extrajudicial confession. 36 is even in this case, the extrajudicial confession was made before the Gambura, Your Lordship. And though he was acquittal with regard to that, the statement were not corroborating, or the prosecution witnesses statement were not corroborating, his extrajudicial confession before the Gambura was taken into consideration, Your Lordship. The next, Your Lordship, is also of extrajudicial confession. Your Lordship may just mark the paragraph that I would like to rely. I won't be reading the entire paragraph, Your Lordship. Paragraph 81, Your Lordship.
Only 81?
Only 81. Now, in this entire case is with regard to if the complainant, informant, and the investigation officer can be a same or not. We are not on that, Your Lordship. However, if Your Lordship will come to page number 10, 5.6, Your Lordship.
5.6.
5.6, Your Lordship. Your Lordship, as I have already submitted, Your Lordship, there is a form under 164, which is full format form is already with the authorities, Your Lordship. The submission that there is no foot marking whatsoever, if there is any defect in the while recording the statement of 164, Your Lordship, that defect can also be ignored if that is not prejudice to the accused in any manner. If I may read, Your Lordship. 4.6. Section 462 of the code provides that no finding, sentence, or order of any criminal court shall be set aside merely on the ground that inquiry, trial, or other proceeding took place in a wrong session division, district subdivision, or other local areas, unless it appears that such error has been in fact occasioned a failure of justice. Section 463 of the code provides that even if there is non-compliance in recording the confession under section 164 of the code, even then the same may be admissible if such non-compliance has not injured the accused in his defense on merit and that he duly made the statement recorded, admits such statement. Your Lordship will see the admission made. Even in 313, he has admitted to the fact. I'll read it again, Your Lordship. Section 463 of the code provides that even if there is non-compliance in recording the confession under section 164 of the code, even then the same may be admissible if such non-compliance has not injured the accused in his defense on merits and that he duly made the statement recorded, admits such statement. Section 463 of the code provides that no facts, finding, sentence, or order passed by the court of competent jurisdiction shall be reversed or altered by the court of appeal on account of any error, omission, or irregularities in complaint, summon, warrant, proclamation, order, judgment, or other proceeding before or during trial, or in any inquiry or other proceeding under this code, or any error, irregularities in any sanction for the prosecution, unless in the opinion of that court, a failure of justice has in fact been occasioned thereby. Thus, under section 465, irregularity in other proceeding under the court shall not lead to reversal of conviction unless it led to the failure of the justice. Irregularity in the investigation would not lead to acquittal unless failure of justice is shown. Now, while summing up the entire submission, Your Lordship, my first submission is that first was the missing report. There was no pressure on the accused to make any extrajudicial submission, Your Lordship. They were inquiring on the missing of the girl, Your Lordship. The accused came out with the permission. He made a confession before all the Gamburas that he was last with the victim, Your Lordship. Now this chain continues that after cinema hall, where did it go? He said that after cinema hall, he has confessed that he was with the victim. Now, though he has retracted the same of his statement under 164 that after he came out of the video hall, whatsoever happened and how the girl fell in the George, Your Lordship will see that he has completed the chain because that retraction, the question put up in 313, Your Lordship, he did not, some of the questions he had denied, but major of the questions, Your Lordship, the important questions, Your Lordship, he has not made any necessary proper this explanation, Your Lordship. That chain continues, Your Lordship. Just because he has retracted does not mean his confession will not be taken. There is a corroboration, Your Lordship. Last seen by the friends with him, he has made a judicial, extrajudicial confession of he being the last person to be with the victim. Then his statement that whatsoever happened continues, and next day he goes to he joins his duty. And after the body of the victim was found, Your Lordship, as his own submission, his own statement, Your Lordship, that he has, by fear, he has covered the body of the victim by boulders and mud. That is how it was, the dead body of the victim was found, Your Lordship. That completes the entire chain, Your Lordship. And also, Your Lordship, as far as defect in investigation and defect in recording of 164, it's clear, Your Lordship. Judicial, he was not in the police custody when his when his confessional statement was being recorded, Your Lordship, which is also clear in the record, Your Lordship. And with regard to the application, Your Lordship, the application that they have pointed out, saying that an application was made for retraction, Your Lordship. Even that though it's in the record, Your Lordship, it has not been exhibited, Your Lordship, in any manner, Your Lordship. Nor there is any order if the application was accepted or rejected or if it was filed, because there is no seal of the court in the notification, Your Lordship. Now, the prosecution has clearly taken into circumstantial evidence, last seen theory, as well as the evidence of the prosecutions, Your Lordship, 164. Not only 164, take into consideration the entire corroboration of the evidences, Your Lordship. The prosecution has clearly made out a case, and he has rightly been convicted under the 304(2) of the IPCA.
No, no. Then again, the 29 or 30 will be fixed, otherwise I don't have time. Now I don't have time. What, any submission made?
5 minutes, only 5 minutes on the submission of my learned friend.
Only 5 minutes.
My learned friend, while submitting, she is taking the star marks. The PW
Scar marks was described by the doctor.
doctor.
Yeah.
But
and
doctor has
therefore
opined,
he
doctor has
explained that
opined in
the
his.
scar marks, he refused other scar marks, he denied about the other scar marks. Only stated that
She
he had
is
some
taking in
scar
330
mark in his
statement.
face.
She has not given any. He has not given any. Accused has not given any explanation.
Only
But
explanation given that he
doctor has
some
opined.
scar mark on his face because of pimples done.
The doctor opined that scar marks. How it happens when he has examined the accused on 29/9, and doctor said that 4 to 5 days taken to recover from the scar marks. 29/9, and the scar marks has already recovered. It was the version of the doctor. The wounds used to heal after 4 to 5 days. Thereafter, I cannot specifically say the cause of the instrument, how the wounds or injuries were caused. And it was doctor who examined the, I have examined him at Assam Rifle lockup room. I have examined him on 29/9/2011. And the incident happened on 15/9. It is after 14 days. Only 4 to 5 days it takes.
Yes, absolutely. There is no denial on that. There is no denial on that.
Because that's why there's a scar mark there, because this fresh wound was not there.
It's a fresh
It
wound.
were the scar marks. That will be there. Because it takes 4 to 5 days to heal the wounds and all, and thereafter it will be a scar.
So that's why I am submitting. The star marks are before 4 to 5 days of 29/9. None of
That is not the most probable issue. Question is that as per doctor, for the healing of any wound and all to become a scar mark, it takes 4 to 5 days. And the doctor examined him on so and so, as we have stated, I have not seen. But after 10 to 14 days, he was examined. So he found some scar marks on his body. Fresh wound was not there because it was already healed.
already healed.
Yes.
But on which date it was scarred mark, it was not there. Doctor cannot examine on that. Now, on the other part, in the whole scenario, two statements. One is extrajudicial and another is judicial confession. Extrajudicial before the committee, and judicial confession before the magistrate. Extrajudicial was made after coming out from the Assam Rifle, and he has been taken, which was he retracted in his 313 statement. And the judicial confession, that is also he has retracted in his 313 statement. That and the IO of the case has placed the application on 28/10 and 31/10. The judicial statement has been taken. I have already submitted that nothing has been asked about the treatment taken by the police authority on him by the magistrate, and no legal aid has been provided to him during that period while recording the judicial statement. No legal aid has been provided to him.
Legal aid?
There is a judgment.
Already submitted. Already submitted. Already submitted. Already
It has to be
submitted.
reported by
Already
the
we have submitted a
magistrate.
judgment.
Yes. Okay.
And moreover, one thing is that
And some other judgments we will also rely.
putting of 161 instrument and that are almost identical. On the reporting. Almost identical. GK statement কি হয়েছে?
164 statements
almost identical.
And another one she has taken, the charge sheet, which was prepared by the IO. The footing of charge sheet, the scenario, factual scenario was almost same as it is in 164 statement. Almost same. Because 164 statement taken after that charge sheet file. And in PW7, the father of the accused person, he has, my learned friend has accounted that on 15th evening, I don't know where they were, but on 16th, they went to jungle for collection of timber, some timber post. They went, they brother and evening he joined the this army unit.
Yes, that is on 16th.
That is on 16th. And one important seizure witness, in case witness, Kohli Yobin. She has not been called as PW. And also Lydie Yobin, who is also available on that day. She was also not called as PW. And
You have submitted already.
I have already submitted. And the chain from the video hall, there is no chain up to the place of occurrence. It's only on the basis of 164 statement. And that too also we have said that this was the retracted statement. That is my submission.
Obliged, Lordship, for being a 5 minutes with us.
No, it's okay.
Madam, in item number, madam, 8 and 9, madam, there is an increase order, madam, that may be continued.
8 and 9.
8 and 9.
8 and 9.
Judgment date made.
Huh? Which one? I don't know. Lots of matters have been fixed. I don't know if it is possible, then definitely I'll do it.
It's available. I'll go to CD, madam.
Huh?
CD is available, madam.
Huh?
CD is
CD is available.
Yes, madam. But
Which one item number 8 and 9?
8 and 9. 8 and 9.
8 and 9, okay, I'll list it.
Student.
You only
Alone
8 and 9.
judgment date will be.
Pursue.
It will be under seal. It will be reserved. Judgment is reserved. Item number? Yeah, 12th to 9th of February. Rest will give him. Okay.
पुनः परसों कर दो ना 25 कर दो मर तो हम लोगों का 8 और 9 हाँ सीडी भी आया है तो एक वाला को तो मंडे कर दिया ना
पता नहीं कितने बना
कल करिए ना जब आप बोले
ये ना इसको वो कर दो ना ये ना ये सीधी एक आ गया इसका
item number 7.
7 का कल का सीधी क्या 7 का उसका सीधी हो गया कि कुछ भी केस नहीं जल्दी हो जाएगा कल कर दो हाँ
बाकी लोग कब होगा ना बाकी लोग रैंडम
नहीं करना
कल के 24
6 वाला का सीधी आया ही नहीं छोड़ दो इसको ना 1 वीक का बात कर दो
1 वीक ना
2 वीक्स मांगा ना तो कल उतारने से भी होगा क्या हो जाएगा 1 वीक का कर दो
सीधी नहीं आया तो 1 वीक कर दो
ये आप कर रहे हैं
हाँ हम कर रहे हैं
आयो
हाय
हागा ये हेलो दीदू भाई
कौन सा
आफ्टर 1 वीक ना
हागा
कौन है लगाए
क्रिमिनल
ओ वो
उसका बाद
लक्ष्मी दी का है ना लक्ष्मी दी आया नहीं है
विकी ना विकी एक क्रिमिनल
ये
ये तेरा वाला ना
Item number 6, no?
उसको आप 1 वीक कर दो 2 वीक्स कर दो 2 वीक्स ना काम नहीं है
और ये एक पास ओवर था ना
8 नंबर कितना कब होगा सर?
हाँ ये
हाँ कब करेगा
इसको तो वो कर दो 2 वीक्स में कंटिन्यू करो हाँ
वो तो करेगा कंटिन्यू नेक्स्ट स्टेप में कंटिन्यू हो जाएगा कि कोर्ट का ऑर्डर नहीं है वो कंटिन्यू हो जाएगा क्योंकि कोर्ट नहीं बैठा है तो कंटिन्यू
Item number 8 का कब होगा?
19 कल
Yeah, Tadar,
Yeah.
yeah.
डाल डाल दो
He obey.
ये
Settlement.
मेंशन कौन किया है? बच्चे का नाम है
ये आपका में
ताफिन का
गीता गीता बता क्या था ये
और एक
बीता बा बीता बा ना
हाँ गीता बता गया
कल कर दो
मोरो मोरो
Kini ko? Kini
किन्हीं
आता?
किन्हीं ये कहता है लक्ष्मी कहता है छोड़ दो उसको
नहीं विश हाँ बोलेगा
2 weeks
2 weeks कर दो
मैडम कब तक लगेगा बैठेगा नेक्स्ट वीक
नेक्स्ट वीक भी है
बिकॉज क्या है 2 week इसको आप करेगा ना क्या करे 2
नहीं
weeks
हमने करे नहीं ये क्या है ये
आपको सर का है
मैं भी 2 weeks
2
कर
weeks
दो
कर दो हाँ इसके बाद ये लक्ष्मी का क्या गया ये अतो वाला
चलो
ये आगे
आगे में क्या
लेगा तो नहीं क्या था
किनी आता
किन्हीं
नहीं नहीं
इसको भी
तो ये ऑलरेडी मेंशन कर देना
चलो ले ले
पता है इसको 2 weeks ना
हाँ हाँ
इसका कब है
ठीक है
8 का कब है
ये देखा
25
अरे कोई नहीं तो
25
हम करते हैं
और ये 24 को कब होगा ये 25 आइटम 24
फाइव को बोलते हैं
आइटम 24
फाइव को नहीं माने से 2 वीक्स बोलते
इसको डायरेक्ट
24 ये कब लेगा ये
हैं कभी तो नहीं फिक्स कर लेंगे
फिक्स बोल के रखेगा
अभी